So there will be no additional time allocated. So we need to use the time that we have allocated today. And I trust that we will have meaningful conversations. I want to also indicate that it is important that you are connecting from a safe place, and you are connecting from a place where you will be able to pay attention to the proceedings, so that we do not have to find ourselves dealing with the same issue more than once. And we also would appreciate if, when you are given an opportunity to talk, you are at a place where we will not be interrupted by background noise. So if we can be assisted with that, we will sincerely appreciate. Also note that this engagement, it's being recorded. So let's be aware of that. I have in this meeting the member of the regulator board, Ms. Nomfundo Maseti, who will be addressing us, doing the opening remarks in this session. Immediately after, I will welcome our legal advisor, senior manager, Advocate Mboniseni Murati, to also engage the members with regard to the legal matters surrounding this tariff application and tariff processing. And thereafter, I will make a short presentation, and when I am done, we will open up the platform for discussion. But I also want to encourage that as we proceed and as the speakers come in, you are welcome to put comments in the chat. You are also welcome to make note of the comment that you want to make or the question that you want to ask, so that at the time when we open for questions and discussions, you can make use of that opportunity to do so. I also would like to, before I talk to Ms. Maseti, I would also want to give an opportunity to our communication senior manager to indicate, in terms of the arrangement of today, things that we need to be aware of. Mr. Kabela, over to you.
Thank you, Mr. Matebula. It's just to bring to the attention of the attendees that this workshop is live streamed, so there are also others that are joining through our social media platforms, including members of the media. Thank you.
Thank you, Mr. Kabela. Ms. Maseti, can I take the opportunity to allow you to do the opening remarks?
Thank you very much, Mr. Matebula. Good morning, everyone, all of the attendees and the representatives of the municipalities, as well as the private distributors that have joined us through this platform, and also to the other members of the public, stakeholders, and the representatives of various media platforms that may have joined us through the social media platforms. Thank you very much for making the time to join us in this workshop today. This workshop really is a workshop, or is the first step that we thought is critical for us to engage with the industry and trying to address some of the concerns and some of the things that we can actually find some solutions. This is exactly what I was talking about. Can you please join with your mic muted, please? Otherwise, then you are really disrupting our proceedings. So the purpose of the workshop came about as a result, firstly, of the notice that was issued by NERSA on the 12th of November 2025. That notice was calling for the distributors, all distributors, the municipalities and private distributors, to submit their applications for the municipal tariffs for 2026-2027. The reason for that, we were trying to make sure that we address several concerns that were raised with NERSA. One of those concerns is that NERSA was being criticized for starting the process of municipal tariff determinations late. I think also there seemed to be a lack of or insufficient understanding of the fact that NERSA can only react to applications that have been submitted to NERSA. So we thought that let us try and take the initiative to then remind the municipalities to submit on time. The reason we wanted to take decisions before the 15th of March, it is because of the issues of Section 43 of the Municipal Finance Management Act, which states that the applications for tariffs must be made, the decisions must be made before the 15th of March. So please, if you can flag that, because it is one of the issues that we must just clarify and find each other, so that with the interpretation and also going forward in terms of the plan that we want to put in place as these stakeholders, including the regulator, at least we understand each other going forward and manage the process much better and smoothly going forward. And also do away with the lateness and the delays, because those are some of the things that subject us to the court, to the court challenges or to legal challenges. You will also note that with the recent court ruling and the clarification on the orders, on that initial ruling that was given about 2 months or so ago, that the court has touched on the issue of the lateness as well as the delays. And it also touched on the fact that NERSA tries to accommodate the municipalities. You will find that in the judgment when you read it. Also, we were concerned about the fact that recent court decision criticized us in as much as we were trying to sort of accommodate and understanding the risk of municipalities not having the tariffs for the whole financial year, that it will have serious implications on the municipalities and customers of the municipalities. So we have had issues where you will find that a municipality or two municipalities submitted their applications like 2 days before the deadline. Obviously, then you leave NERSA, with no time at all to undertake the public consultation process. So these are the things that we would like also just to touch on. And now the court ruling delivered yesterday, it even touches on those things, understanding that there are those instances where NERSA is put in such situations. But unfortunately, because it is a public body, then NERSA, even if it is put in that situation, as much as it's trying to accommodate municipalities, then it falls foul of complying with the statutory requirements of following 30 days, or if it's shorter than 30 days as required in PAJA, 30 days, and then if it's shorter, it will be 14 days. But then there must be a consultation on that 14 days if you're going to truncate the process. So those are some of the things that we need to just iron out. So the purpose of this session is not really a complaint a session. It is just a session that is forward-looking, because you will also notice that we said maybe let us extend the deadline to January. But in between, let us have the workshop, because the workshop then will bring us closer to a feasible solution. And that solution is the solution that we will all then try to respect and have a plan going forward, how we would like to handle the process going forward from our side and also from the side of municipalities without compromising each other. And there will definitely be a change because also of the court rulings that are guiding us. And yes, having looked at the delays that have been there, and also there are instances that Mr. Murati is going to touch on, where the court makes it clear that we must try and avoid prejudice for those municipalities that submitted in time, so that their tariffs or decisions must be made in time, firstly, and secondly, for those that then submit late, the court states clearly that unfortunately they might not have the tariffs for that particular financial year because they are late, because NERSA will have to comply with the constitutional requirement also in terms of PAJA, the 30 days that NERSA must follow for public consultation. So please keep those in mind, because those are the things that I'm saying. Through this engagement, we need to find a way of how we're going to manage the process going forward, complying with the laws. And the court now says that all along, this has not been done so well. And these delays and lateness must now be put behind so that we try and do what we have to do. There is also the issue of ERSA, as we all know. That also has been addressed by the court, and Mr. Murati will touch on that, so that the sequencing as well is going to work out, but also the municipality will probably also have an opportunity to engage if they wish with ESCOM regarding the issues that are affecting them, and also with regards to the ERSA and other costs that the municipalities would have to absorb as a result of bulk purchases. So you can also decide how or make some proposals as to how you believe those could be addressed. I would like to stop here now, having put or set the scene with regards to what we are looking at in this workshop. Really, it's a forward-looking workshop. It's an engagement looking for solutions. And even the date now that we had extended, we need to find a way now, given the recent ruling that was delivered yesterday by the court, to see, because the court states now that the decision must be on the 5th of May. So we need to look carefully at that, given also the fact that ESCOM has not yet applied for the ERSA. So we need to get into whether this must be implemented immediately. They will clarify that, from the legal point of view, as to when are we expected then to comply with that date of the 5th of May. If the court has not given us any sort of transition, and we are expected to implement that order immediately, then we must be able to agree with regards to the process, so that at least the applications are submitted in time, and so that we can be able to follow the the compulsory consultation process of 30 days before we take decisions. If you can also just flag that, because it is important as a way forward and as something that we want to make sure that as we complete this workshop, that we will be able to come to a feasible solution with regards to that in terms of this year's process, or 2026-27 a process. I believe I have touched on the key things. I will come in at a later stage, but this is just to indicate the purpose and also the expectations with regards to today's engagement. I think the timing is perfect of this engagement, given the fact that also there was the initial ruling, and there's additional ruling now on the orders, because at the time it was temporary orders, and then the parties were required to then provide reasons why those temporary orders should not be made the final orders of the court, and the court considered the submissions that were made by the parties, and that is why then yesterday there was a court ruling which then clarifies what has been the challenges that gave rise to the lateness of the decisions, and how this should be corrected so that the status quo cannot remain and things must be done right. And that is really the tone of the ruling of yesterday. With that, I would like then to hand back to you, and you are welcome to this workshop, and I'm hoping this is not the final engagement. We will also engage should there be certain challenges also from your side, if you wish that NERSA could organize a workshop so that we can deal with other issues, not only the process of the municipal tariff determinations. I would like to hand over to you, Mr. Mathebula, if you can take over from here. Thank you.
Thank you, Ms. Nomfundo Maseti, the full-time regulator member responsible for electricity and gas at the National Energy Regulator of South Africa. I would like to therefore take an opportunity to welcome. Please mute. Yeah, I do not understand how people are in meetings and still having conversations with everyone else. Let me use the opportunity to welcome Advocate Moratti, if you can come in and talk to some legal matters surrounding this tariff application and administration process. Advocate Moratti.
Thanks. Can you hear me?
Yes, we can hear you. Thank you.
Right. So good morning and good morning, colleagues on the platform and the regulator members that are on board. Chair, I would take
Mr. Moratti, you are on mute.
You are muted.
Oh, sorry. I think that it's automatically muting itself. Okay. Chair, I was saying, can you probably, because I think I have challenges in showing the slide 6, which I would at a very high but principle level touch on it in terms of the hierarchical nature of the activities that brings out the reflecting on the jurisdictional issues relating to the mandate of the energy regulator, as well as the relationship between what we do with the municipality, not only on the basis of the licenses that we issue. Chair, with your permission, I think I would depart from, thank you, reflecting on one of the obligations that is placed on the energy regulator. In terms of Section 10 of the National Energy Regulator, there's an obligation that when we take decisions, those decisions must take into account and be consistent with the Constitution and the applicable. Madam Asset.
Okay, that's fine. So,
okay, and applicable legislation. And in that regard, the applicable legislation, we have the Municipal Finance Management Act, we have the Municipal Fiscal Powers and Functions Act, we have the Municipal Systems Act. That is in terms of decision making. But in terms of the mandate that the regulator is entrusted with, Section 3 of the Electricity Regulation Act makes the regulator the custodian of the regulatory framework for the electricity supply industry. And Section 4 of the Electricity Regulation Act provides the detailed mandate of the energy regulator with regards to the issuance of licenses, with regards to the approval of prices and tariffs, and also the enforcement of non-compliance. So those becomes the fundamentals that that when we deal with municipalities now, we deal with them as licensees and not just as municipalities. That is in terms of the mandate that we have. Section 15 of the Electricity Regulation Act has a prohibitory provision, which is Section 15.2. It prohibits any licensee to charge an unapproved tariff to its customers, whether even through the usage of any contracts or agreement. The regulator retains the power to have to approve that tariff to be charged to a customer. Then there is an interrelationship between what Section 15.1 relating to the tariff principles with the electricity pricing policy, with Section 74.2 of the Municipal Systems Act. They both deal with the issues that were not talked relating to the judgment, relating to the review and setting aside of the usage of the guidelines and benchmarks. Those provisions of the Section 15.1 of the Electricity Regulation Act, Policy Position 23 of the Electricity Pricing Policy, and Section 74.2 of the Municipal Systems Act creates a relationship in terms of what is it that needs to be factored into the determination of tariffs. And this has been insulated in a manner that if those components are missed, then the decision of the regulator becomes exposed to a judicial review for it being irrational, unlawful, and not consistent with the provisions of the law. So there is that obligation on not only on the decision-making side, but there is an obligation on the licensee to ensure that that which is being submitted, it is compliant to those tenets that are provided in Section 15(1) of the Electricity Regulation Act, the electricity pricing policy, which generates the requirement to develop the cost of supply, which will then accompany the tariff application, which becomes the source information of where the tariffs that are being applied for is based on. And Section 74(2) of the Systems Act touches on the same issues to say the tariff that is supposed to be generated. These are the components that it must be anchored on. So there is that similarity between the municipal legislation and the regulatory legislation. But when we do that, and in reflection to several of judgments that some of them, they are not related to municipal tariff, deriving from the provision of the Constitution that talks of a just administrative action and enabling legislation, which is the Promotion of Administrative Justice Act and its regulations. Our also legislation, the National Energy Regulator, it touches on the very principle of the constitutionalism or the procedural fairness in the processing of applications which the regulator must determine. Courts have pronounced in terms of to what extent can we go on that. So when we take our decisions relating to tariff applications of the municipality, there is that obligation on us to ensure that we consult all the members of the public that will be affected by that decision. And that consultation, the courts have pronounced on it to say it must be a meaningful consultation. And meaningful consultation relates to the time issue or the days, but it also relates to the content of what is being put out there for consultation by that the stakeholders are expected to consult. Hence, they use the words meaningful consultation. The documents that we provide stakeholders to look into must enable them to provide comments that when a decision is made, those comments would have been taken into account. So if the information is not sufficient and the decision becomes invariant to what has been placed out, that also places an exposure of the decision to a review on the issue of a breach of the Constitution in terms of the right that is enshrined in, or the breach of the promotion of administrative action in terms of the procedural fairness. So those issues are what now are built up into how we are supposed to be processing the applications. There is a substantive component, which the substantive component is dealt with by Section 15 of ERA, the electricity pricing policy, and the Section 74. They deal with the substantive issues. And PAJAT now deals with the procedural side of issues. So therefore, the two combined, the decisions of the regulator must be both substantively correct and procedurally correct for them to survive the legal testing master, or the so-called the legality issues. Chair, I would want to, having introduced that jurisdictional issue, I would come to the case laws, and in dealing with the case laws, the three case laws, they would also have reference back.
Sorry, Mr. Borati, your slide is not moving. I'm not sure whether it is just from my side. As you are speaking.
when we structured, we just made notes. Chair, we would provide it to members at a later stage because we made just this slide as a principal highlight, but the notes will be providing post the workshop. I think that was the mistake that we have made in the development, and we apologize for that.
That is fine. Proceed, Mr. Murati. It makes sense. They will listen to you.
Okay, then I would move to the case law, which relates to the three fundamental judgments that touches on the municipality and the regulatory work that we do. The first one is the 2022 judgment, the Nelson Mandela Chamber of Business. As NERSA and the approval of municipal tariffs, we used to use what is called the Municipal Tariff Guideline and Benchmark. And in that judgment, the court found that the tariffs that we approve using that particular method, it's not cost reflective, and it's not based on the cost of supply. It's not compliant with the Electricity Regulation Act. Therefore, the continued usage of it would be a perpetual support to the unlawfulness of the decision-making process. So the usage of the municipal guideline and benchmark was reviewed and set aside, and the regulator was required to develop a methodology that will enable the decision-making relating to the tariffs to be compliant with the law. And the cost of supply framework was revised and published for the municipalities to take cognizance of and to process their tariff applications in line with that. In that judgment, we were given a grace period of 12 months because the appreciation was that we having to revise that, and the amount of work required for municipalities to come up with their cost of supply, it might not be an overnight issue. That grace period that we were given was for the period until 23-24 tariffs. That period has lapsed, meaning that from 24-25 onwards, the tariffs that are supposed to be approved for municipalities, they are supposed to be based on a cost of supply and compliant with the Electricity Regulation Act, which is Section 15 of it. And we understood the challenges that might be placed. And in that particular year, we had a COSO called the cost breakdown structure to mitigate the challenges that may come out for municipalities not to have approved tariffs, and the dynamics or the challenges that it can pose on the decorum of the electricity industry in the instance where municipalities would not be having approved tariffs. And having utilized the cost breakdown structure, that was then followed by a court application by AfriForum to compel us to say that which we have to consider in approving municipal tariffs. It cannot be anything else except based on a cost of supply. And those municipalities that have had their tariffs based on a cost breakdown structure, they were given a number of days to have to bring their revised application post the 1st of July. But the unfortunate part in terms of that judgment, by the time it was issued, the financial year of the municipality had already commenced using the tariffs that the regulator has approved. Based on the cost of supply, those municipalities that have submitted cost of supply, and those that were approved using cost-based structure. And that judgment will raise the issue of mootness. That judgment is still under appeal to date. We raise the issue of mootness of the judgment that by the time the court pronounced itself, we have already moved from the stage within which it can still be given effect without the court being exposed to breaching the provisions of the law in terms of MFMA, in that the municipalities must implement their budget from the 1st of July. So if the court is coming out to pronounce on that, the MFMA has its own recovery provision in the instances of variance. So the court has delayed making the judgment. So we have filed our appeal on the basis of the mootness of the judgment. So those ones, to date, those tariffs are applicable. They've been applicable until such time that the appeal is heard and finalized, and the outcome comes out in a whatever manner that it is. The last judgment that we have, it had two parts to it. It's an AfriForum judgment as well. The first part was the interim order that was made in end October to say in two parts. The one, it dealt with the procedural fairness of the process that the regulator adopted in considering municipal tariffs. And in that time, one would recall that the tariff applications of the municipalities for the period 2025-26 have been submitted in different times of the calendar of the financial year for them to be able a tariff approved for implementation. And in those time periods, the varying time periods, the regulator was exposed to either rejecting are being brought on the basis that it will not be able to meet the procedural requirement to validate the decisions. Alternatively, to exercise a discretion, but the discretion can only be exercised to a particular point. And my colleagues, I believe, when they talk at a later stage, they would reflect on some of the tariff applications that we received. We received them for like 4 days before the cut-off timeline that we were given. And to just take a step back in terms of what this whole changes. Section 43 of the of MFMA has a provision that it determines the time period within which, the upper limit of it has to be 15. The proviso to that section is, if that time period cannot be met, the Minister of Finance discretion to approve an extended period that the decision can be made relating to the upper limits of the municipal tariffs. But that time period, it's all about the implementation of such a decision, that if that time period is not met and there is no approval by the minister, the decision of NERSA relating to municipal tariffs would not be implemented in the coming financial year of the municipality. It will have to be implemented in the year to come after. So NERSA has been approaching the Minister of Finance for the approval of the time period to be extended post 15th March, but before the time that before the implementation date, which is the beginning of the financial year. So last year we were given until the 20th of June to finalize approving the tariffs of the municipalities. We proceeded to do that, but some of the tariffs of the municipalities came in 3-4 days before that cutoff timeline, which when you have to do the notice and comment, PAJA, the Promotion of Administrative Justice Act, says you must do it for a period of 30 days. And if you have to deviate from that, you need to advance reasons, but you cannot deviate to do it for 1 day. You have a spectrum within which you can say there is an exercise of discretion because of circumstances that necessitated that. So we didn't even have that timeline to enable the meaningful consultation with stakeholders. We proceeded to have that tariffs approved. So the AfriForum judgment reviewed the process that we followed and found it to have a lot of shortcomings, and it was set aside. But the setting aside of the procedural unfairness part on the side of the regulator did not impact the validity of the tariffs that were approved. So the tariffs of the municipalities that were approved, despite the challenge relating to the procedural side of it, remains valid to be implemented through the financial year by municipalities. But now the court judgment has come out to set out, one, the issue relating to the procedural fairness, that the regulator is bound to have to do the procedural fairness, whichever means that we would be adopting. It has to be given effect in terms of PAJA. And if we have to deviate, our deviation should be to such an extent that it can satisfy the court that the deviation was warranted. But the exposure to that part which the judgment has cured was that there was never a time period that was set which was legally, to say, binding, that the municipalities, all of them, this is the cut-off date for the submission of your tariff applications. Now the judgment has come out and set timelines that must be observed. One, it has taken into the consideration the ESCOM process to say the ERTA of ESCOM must be submitted by end August, and the finalization of it, which the regulator must make pronouncement on, is the 31st of January. So by 31st of January, the regulator must be able to inform stakeholders, including municipalities, that the retail tariffs that ESCOM will be implementing for the coming financial year from 1st April, this is the tariff that will be charged. And also the court judgment has set a timeline for municipalities that all the tariff applications must be submitted to the regulator by the 20th of March. So it now occurs the part where we're receiving tariff applications 2, 3, 4 days before the cut-off timeline of the minister. And the regulator then, the judgment proceeds to say the tariffs of the municipalities must all be finalized and be approved by the 5th of March. Sorry, by the 5th of May for implementation from 1st July. I wouldn't want to get into the conflict of judgment with law in terms of whether the change that the judgment has given, which is the timelines, what effect does it have on the provisions of Section 43 in terms of the discretion of the minister, whether the two of them can go hand in hand or one kills the other one. But the court did not pronounce on the unlawfulness or unconstitutionality of the powers of the minister in Section 43. So meaning from now on, the timelines that will be implemented, because the judgment didn't give a grace period within which this judgment cannot be implemented. It was issued as is, meaning it's effective immediately. But we have the industry regulatory dynamics in terms of how to therefore deal with some of the issues in the absence of receipt of, because the judgment cannot have a retrospective effect without pronouncing itself on that the date of the 31st of March, 31st August for the ERTA submission, the court did not give it retrospective effect to say, if it hasn't been submitted, this is the new timeline that it should be. So these are the issues that probably individually or by municipalities, ESCOM or ourselves, we'll have to look into. How do we then give effect to this? Is it a matter that may require approach of the court for indulgence in terms of giving effect not this financial year, or would they have to grin and bear and move on with the manner that it is? Chairperson, I think from my side, in terms of creating the jurisdictional space and the relation between the municipal operations and the exercise of the regulatory powers, I would end it here.
Thank you very much, Honorable Murati. We appreciate your indulgence. Colleagues, we are going to proceed. I just want to share a few slides with yourselves to put a bit of emphasis on some of the shortcomings that, as a regulator, we have experienced in the past, to allow us to therefore agree going forward on how best can we manage so that, one, we are effective in our decision-making process. Two, we do not find ourselves in contempt of court judgment. One thing that I would like to encourage us to be thinking about at the moment is, if it has happened that the court did not set aside the tariffs that has already been decided by the regulator, what would have been the ramification or the consequences of that decision? So I want us to think about it so that we can understand that some of our conduct and some of our behaviors in how we align ourselves to the process can have serious consequences to us and the people that we serve. So let me not waste time and rather quickly talk to the few slides that we had prepared for yourself to share with yourself today. And I would like to start with indicating some of the issues that have already been talked to, which talks to the legal requirements, the court ruling, which our honorable advocate have already touched on. I would want to talk a little bit about the cost of supply studies and the challenges that we are experiencing or foreseeing as a regulator. I want to also talk about some of the risk associated with us not following and complying to the due dates that are set before us. So I think the purpose has been clearly stipulated and alluded to by Ms. Maseti. But let me indicate that some of the things that we're going to be talking about today stems from the process that we had concluded, let me say 6 months ago, when we were finalizing the tariffs, the municipal tariffs that were implemented as of the 1st of July 2025. There has been a lot of ups and downs between us and municipalities. And we had situations, as Ms. Maseti indicated, where a municipal application was actually received 2 days before the due date that we were given by the Minister of Finance at the time. And that obviously takes away it actually undermines the whole process that the regulator needs to follow. And in the regulator trying to accommodate that municipality, today we find ourselves with court judgments that we now need to abide to. So this could have been avoided if we all had done our part to ensure that we comply to the timelines that have been given to us. It is my understanding that this activity, it's a routine activity. It's an activity that we embark on a yearly basis, and therefore it should not be triggered by a letter from the regulator saying, please submit your applications. That should not be a trigger. This is a routine activity. We all know that by the 1st of July each year, we need to be implementing the new budget cycle, which includes the new municipal tariffs. So it is something that we need to really introspect on and look at how best can we deal with this. It has to be part of our calendar on a year-to-year basis. We have to know by when do we start preparing ourselves to process these applications. It cannot be a process that only waits to be triggered by a letter from the regulator. So as the advocate indicated, we had the 31st of October judgment. Now we're talking the 4th of December judgment, which now stipulates that by the 20th of March, which is obviously going to be 2026, we, as the regulator, should have received all municipal applications. And if you look at this in connection with the date of the 5th of May, which by then we should have pronounced on these applications, it automatically gives the regulator about 45 days from the last day of receipt to the pronunciation. And that includes your weekends. So in that order, you would realize that the regulator will be under severe pressure to pronounce on these tariffs, given the short timeline that the regulator is actually expected to process this. And in this timeline, it includes the time where the regulator should be doing public consultation. And as Ms. Maseti indicated, PAJA talks to 30 days, which it also needs to be included in this process. So it really gives the regulator very limited timelines. And the best way, what can assist the regulator is if municipalities do not wait until the 20th of March, but proactively start submitting these applications as early as possible to ensure that as soon as the regulator receives the application, the regulator will start the process of processing that application, which will include publishing it for public comments. So we need to assist each other in ensuring that the regulator can have ample time to consider our applications, because that has an impact on the quality of decision that it's pronounced at. So I am making an appeal that with the date as it is currently pronounced by the courts, if it is not changed for any reason, let's make sure that we do not wait for the date that is stipulated, but we make sure that we submit as early as we possibly can to allow the regulator to be able to do all the due diligence before pronouncing the final tariff. I will not talk to the legal matters because Mr. Murati has already talked about, but I wanted to just re-emphasize on two things. One being the key dates and key milestones. As per the court judgment, we are now expected that by the 31st of January, we must have announced on the ERZA. And on the 20th of March, we must have received all your applications. And it only, as I indicated, gives us time between the 20th of March up until the 30th of April to be able to do the consulting, the due diligence, and the processing through the regulatory committees to ensure that the tariff is actually pronounced. And thereafter, we need to communicate to yourselves on what your tariffs are. So you can assist us by ensuring that you make your submission as early as possible so that we can have ample time to be able to process it and follow the due diligence so that we do not end up finding ourselves compromising the set process and end up being challenged in courts. The other matter I wanted to talk about is that we always request that municipalities should complete their D forms and submit them by 30th of October every year. In this year, we are sitting at 64% in terms of the municipalities that have submitted. Again, this is one of the things that makes it difficult for the regulator to perform its work if the needed information is not submitted. The second thing is that in many of the submissions that the regulator receives, some of the information is incomplete. At times, some of the information is, to a certain extent, even inaccurate. And that makes things difficult for the regulator. And these are things that we should avoid going forward. As I indicated when I started, that this is a routine activity. We should seek to be improving and doing it better when we are doing it year by year. It cannot be a case where our submissions keeps being error-prone while it is something that we are doing on a continuous yearly basis. When we indicated to municipalities that we expect that municipalities should submit their tariff application, we did receive several concerns from some of you, and we have tried to indicate some of them in here, and I want to talk to why it is important that these are addressed. I think the issue of ERTSA, we are now all aware of what the courts have decided on this matter, and we all need to fall in line and ensure that we comply. There was an issue that was raised about the cost of supply studies. We want to again re-emphasize that the cost of supply studies are actually valid for 5 years unless there is drastic changes to either the infrastructure or to the area of supply and other matters that may influence the outcome of the cost of supply. It is only then that the studies may need to be redone or need to be revised and resubmitted to the regulator. So up to now, we just need to know that the cost of supply studies that we have submitted to the regulator are actually valid for the period of 5 years. So let's work on the issue of the quality of the data that we submit to the regulator. As indicated, this is a routine and we should be getting better year on year. And the regulator is always available to assist, because some of you, we are aware that you would have turnover in terms of officials that are responsible. Please reach out to the regulator and say, please induct this official in terms of the process, so that when time comes that this official should be facilitating this process, the official should be better suited to actually do that. So that is the type of collaboration and working together that we want to have with you to ensure that we don't falter on this process ever again. We don't find ourselves in courts unnecessarily on a process that is actually a routine activity. So as things stand, the courts has pronounced that the deadline submission should be the 20th of March, which in this case it will be 2026, unless pronounced otherwise. So I want to also indicate that we will not repeat what we did this year, where we were accommodative of late submission. So any municipality that do not align to the deadline, their submission will not be considered. There are specific information and things that we need to ensure it's done before these applications are actually submitted. One, the accuracy of the information that we have populated on our DFORMs. We need to ensure that that information is accurate and it's actually submitted to the regulator. We need to ensure that our applications are actually signed by an authorized official. It cannot just be anyone within the institution that attach their signatures and make a submission to us. It has to be people that are authorized by the institution to be able to carry out that mandate. We also want to emphasize that the application should have been passed by council. We have had instances where after we have processed an application and we had been told that council have approved, we later learn that actually council had not approved. We cannot afford such a situation because it compromises both us as the regulator and yourselves. And we therefore cannot defend our decisions to either the public or the courts if we had not complied to what we had actually stipulated on our own processes. We also need, as expected, that the customers that you supply be consulted before this application is actually put through to us as the regulator. And we will need proof of such consultation. So can we assist each other by ensuring that this is actually done? The audited financial statements, it is a requirement that this has to be submitted to the regulator. But many a time, the regulator, it's found in a situation where it becomes difficult for the regulator to actually obtain or receive this information. The cost of supply study, I have indicated that it is valid for 5 years unless there's been changes on the supply area or in the infrastructure itself, drastic changes that actually has an impact on the study outcome. Then the study has to be redone or it has to be updated to ensure that it reflects the correct information. And also note that we are expected going forward to publish this cost of supply studies together with your application when we do public consultation. So those are the things that we wanted to ensure that it's brought to your attention. And this is stemming from the fact that in some of the applications that we had received, we have found that some of them had no cancel resolution attached or proof of cancel resolution. Some of them had incomplete financial data. Some of them did not have the cost of supply studies. And we had to go back and forth with municipalities trying to obtain this information. And given the timelines that I had indicated earlier, we will not have time, my colleagues, to be going back and forth and waiting for pieces of information to be able to regard the application complete. We do not have the luxury of time. So it is important that when these applications are finished and brought to us, this information, it's attached and it's complete. The other matter that we had picked up in the past applications was that customer consultation process was not being done adequately. And we would like to urge that this be done correctly. And again, I must emphasize, it is a routine activity. We are expected to be doing this on a year-to-year basis. We should only be doing it better now and not still finding ourselves failing to consult our constituencies. So let us avoid all these pitfalls of the previous years. Let us do things properly, to avoid ourselves being decided on by the courts in terms of what is it that we should be doing and how should we be doing it. So I would want to indicate some of the risks as alluded to by the previous speakers. If we do not receive the application by the date that is set, then the municipality will not have a tariff, an approved tariff that it needs to implement from the 1st of July. And as I indicated, as the regulator, we will not be bending backwards, we will not be accommodative. We will stick to the timelines. If an application has not been received, there will not be a tariff pronouncement on that particular municipality. The issue of the adequacy of the submission documents, the quality, I have already emphasized. It is important that we make sure that the information that is provided is adequate to allow the regulator to follow its process within the constrained timelines and ensure that it can be prudent in its judgment and its pronouncement of the tariff for the municipality. So we would understand that without a tariff, this will have an adverse implication on your budgets and on what the tariff you need to charge. It will impact you on the AG reports. So there is a lot of risk in failing to comply to the statutory timeline. The biggest of them all is to be found to be in contempt of courts. So colleagues, I would like to end it here and indicate that the regulator is available to support you in ensuring that we can follow this process efficiently and effectively to an extent that it becomes and remains a watertight process, that it cannot be found to have, or it cannot be faltered by any institution for any reason. It is a routine activity, and by working together, we can improve this process and ensure that it's done better. As we continue to engage in this on a yearly basis. Let us make sure, colleagues, that we follow the required processes with diligence to ensure that we receive the correct tariff, we charge the correct tariff to the customers, and no one should find us at fault for breaching any policy, any regulation, or any act which is pronounced in our country. So I would like to end it here. We are going into a session where we would like to get your inputs, and we would like to hear from you. How do you see us doing things better? How do you see us improving? What are the things that can be done differently to ensure that this process, as we do it on a yearly basis, it is seamless, it is efficient, it is effective? Because the decisions that we make, colleagues, have got a huge implication and a huge impact to society. So we will take the first 5 hands. We will take the comments, the inputs. We will take responses, and then we move to the next 5. So I see the first hand is, allow me to call by your first name to assist in the process. So I see Zolani. I see next person after you is Prof. Valley. The next person is Nicholas. I'm not sure if I am missing others. Let me check. Those are the first 3 that I see. So maybe let's start with them, and we will see if there is more.
There's more. There are about 5, ne? There are about 5 already. After Nicholas Mbete, there's Dwananto, or I can't see Dwananto, and Nombulelo Swane. Yes, if they can also just indicate who they represent before they get to the questions. Thank you.
Thank you. Zolani?
Good morning, and thanks a lot for the presentation. The name is Zolani. I'm currently supporting 3 municipalities, that is Bela Bela, Modimolle, and Witzenberg, through a DBSA revenue enhancement project. My focus there is on the cost of supply studies. Firstly, let me welcome, and I believe that will be the song for many municipalities on the deadline of March, given the fact that even the one of January, it was near impossible, given the fact that December and January, not that it's a problem of the regulator, we all know it's a dead month. I've got 4 issues quickly that I want to raise. Maybe 1 or 2 will be comments. In the presentation by Advocate Moratti, there's a slide that you also jumped on the revised the cost of supply framework, just to get a sense whether we're talking about the framework document, which is a guideline, or the tool itself. Regardless, also if the latest documents in the form of the framework and the tool can also be shared. And then secondly, on the deforms, the 64% submission rate and the quality, whether again that 31st of October was just the end, and perhaps there is the window for those municipalities either have not submitted or would like to refine their data to ensure that it achieves a certain level of credibility, whether that window is still open. Then second, lastly, it's on the checklist as you presented. Specifically, I will touch on the 2. The council resolution by council, of course, approving the proposed tariffs. I would rather propose that the approving part probably be changed to supporting to avoid the confusion, because the approval of the tariff by council, including the budget itself, normally takes place at a later stage. Now, using that approval terminology might be confusing or might even lead to some of the councils not even taking that resolution. Rather, it must be a resolution supporting the proposed tariffs that will be submitted. The last one, which also I would say it's not the problem of the regulator, but municipalities will probably come in on the consultation that must be done even before the submission, that is by the 20th of March. Ordinarily, the public participation process entirely on the budget normally kicks in from the beginning of April. That is after the tabling of the budget by end of March. But then what needs to happen, because as I say, it's not the problem of the regulator, it's how municipalities can be innovative. For an example, during the process of consulting on the oversight report as an example, and perhaps have this item of the tariff increase as part and part of the discussions. But also that will depend on whether at that point of those discussions, the municipalities have already determined what will be their tariff increase that will then be applied to NERSA. Thanks a lot. Those are just a few issues I wanted to raise. Thanks.
Appreciate it, Solani. Thanks for that insightful inputs. Prof. Vali.
Good morning, everybody. It's Prof. Vali Padiachi. The role that I'm here in the capacity of the strategic advisor to the AMEU, which is a body, for those that don't know, it's a body that represents all the municipalities in the country from the power side, and we also have affiliate membership. My comments are just a couple of general comments, and then I want to get to why I put my hand up. I think it's just a pity that we have to be reminded, everybody, I include NERSA and municipalities and all the other bodies in the value chain, that we need to do our work. and follow governance, which should be common knowledge. I mean, we should be doing that on a day-to-day basis. I mean, we are parastatals, we are government bodies, institutions, and it's unfortunate that the courts get involved. And you quoted a number of case studies there, and it means that the courts are getting more and more involved, and they're getting more and more pronounced and interrogative in their decisions. And the courts are not doing anything else besides following the law. The courts don't do anything else. That's their training, the judges, etc. is just to go by the law, by the legislation. And it's unfortunate that we have to be reminded to follow the law. And maybe there's good reasons for that and not so good reasons for that. And I don't want to get there. Just to get back to why I put my hand up, there's a number of deadlines that's been put on the slides, and the one particular. So I'm assuming, and I'm representing the municipalities here, that for the avoidance of any doubt and misunderstanding, that the tariff applications is no longer the 12th of December, is no longer sometime in January. It's now the 20th of March. So I'm assuming that that's the date that my colleagues in the municipalities, and if there's any exceptions to the rule, they will motivate for that accordingly. But then there's a couple of dependencies on that. The major dependency is the ETSA. Well, of course, there's cost of supplies and all that, but that's an internal process to the municipalities. But in terms of the other dependencies, which is external to the municipalities, for example, is the ETSA. Now, that's a key dependency because that's January, okay, 31st of January. And if for whatever reasons, I repeat, if for whatever reasons the ETSA information is not available, right, what happens? What happens? So I'd like Nessa to pronounce on that now. And then the other aspect is, and I say this with all humility and respect to Nessa, your work is cut out between 20th of March and 30th of April. So that's 1 month and 10 days. I'm just putting it on the table that I'm hoping that you are fully resourced internally to undertake all your activities between the 20th of March and 30th of April, because there's assessments, I don't know, there's 178, 200 municipalities, tariff applications, plus public engagement. So you have 1 month and 10 days to do that. And then you're going to inform the Munichs by the 5th of May. And then we got to, as Munichs, got to start doing our own internal processes and communicate to the public by 1st of July. So these are all tight timelines. And I'm just putting on the table is that if the timelines are not achievable, not all of them, 1 or 2 of them, then I'll leave it to NESA to make that call, whether you should go back to the court if you need to revise that. But that should be more the exception than the rule. If we have a timeline given, it should be practical, acceptable. I mean, for example, the 12th of December timeline was not practical. So I'm just putting it on the same line. Let me leave it there, Chair. And so those are my comments for now. And thank you very much for this session. As I say, it's unfortunate that we have to have a session like this where we were to remind ourselves as to that we need to do our job. Thank you.
Thanks, Prof. Nicholas? Is Nicholas still with us? Okay, I'm not hearing Nicholas. Maybe his questions were Ndomato. Colleagues, can I confirm that I'm audible? Okay,
yes,
go for it. Go for it. Yeah. Thank you.
No, thanks, Chair. I think I must join the the other colleagues that have spoken earlier to say we want to welcome the decisions or processes that the regulator has put forth now, and also emphasize. Before I start, I apologize. I'm Ramato Muchidza from the city of Tshwane. For those that I also comply with Mema Seti, what she said, we must say where we come from. The point is that we welcome these aspects, and of course, I share the important aspect that Prof. Valley raised, that it cannot be that colleagues, we have to be reminded by or be taken to task by the court for us to do what we're supposed to do. Whether we all know that the requirements for us to have applications of tariffs must be able to be done in terms of what the law provides for. And in this instance, we find that it can't be that we must celebrate ourselves or clap hands for ourselves for doing what we're supposed to have done from the onset. That's the first comment. And I think that the timeline that goes to March, I think they are fine. And one of the key considerations that all of us as colleagues from municipality need to consider is that we need to understand that electricity tariffs, just like any other tariffs, must be treated independently from the process of whatever the budgeting. They are just inputs towards the budget processes. They cannot be seen in the spirit as if no, you cannot do it because the budget process was completed by May, all the stuff in that fashion. But we need to ensure that the consultations we are seen to have consulted adequately, so to ensure that we take into consideration these aspects. So I just want to seek an indulgence with the regulator, because in some of the submissions that we were required to do is that in a case when a municipality and there's decisions of the AGSA in your financial statement cannot be determined. Therefore, the regulator must be able to be flexible to look at other inputs that are submitted as part and parcel of the suite of data that are available for considerations. So that we don't have a scenario where in those municipalities, when the AG said, no, your statements, we cannot make a determinations. Therefore, it means that you don't have an outcomes. The AGSA will not have make a pronouncement. Therefore, we'll need to look into that aspect in that fashion. And I think that the issue around there, I think all of us were acknowledging the shortcomings, and we will want a scenario that going forward, these aspects, both, and unfortunately, ESCOM is not here, but ESCOM and the regulator must make sure that at least on time, the exercise processes are attended to adequately, so that we can then become an input towards how we meet the requirement as such. And then we'll deal with that aspect. I think that last, as I said, I just want to confirm that the deadlines of March for an application that is informed by our own processes, it's adequate, and I think that we welcome that. Thank you very much.
Thank you. I see Mbulelo was the fifth hand. Are you there?
A very good afternoon. Yes, I am. Firstly, thank you to the regulator for arranging the discussion. I was mostly covered by the previous two speakers, so I'll be waiting for when the regulator is responding regarding what happens if there is any delays in terms of the EFTA approval. Thank you.
All right. Ms. Masetti, do we stick to the 5 or should I continue and take another 5?
Maybe let's take another 5, but if she can indicate from which municipality is she representing, Nambule?
Sincere apologies, colleagues. My name is Nombulelo and my surname is Zwane. I am representing Stellenbosch Municipality. I am the head of electricity at Stellenbosch Municipality. Thank you.
Thank you very much. Colleagues, if I miss someone, you must highlight. I see.
Apologies, Chair.
Days.
Can I come in?
Yes.
Okay, thank you very much, Chair. I just got cut off. It's Nicholas Mbete from Emakhazen Local Municipality in Mpumalanga.
Sure. Thanks, Nick.
Yes.
Yeah.
Okay. Mostly, the previous speakers have covered me. Let me first start by appreciating again this workshop that we are having today, and also the confirmation that due to the issue of the staff turnovers and everything, NERSA is willing to assist us as municipalities so that we can be able to train other staff members, as I think it's one of the challenges that we are facing here in Emakhazen, that when I'm not there, then there's nothing that is taking place. Let me start by appreciating that. Then the issue of the approval, let me say the application of the application process, and also the budgetary processes, we have been covered on that. The responses. So I think on our side as a municipality, because we'll be continuing with our IDP processes, then we'll just put in the tariff application and also the tariff, the proposed tariffs application as part of that program. Maybe one last question that I wanted to check with the regulator. I remember the municipality performed its cost of supply study 2 years ago. Then as part of the cost of supply study, it determined that the municipality was undercharging by 18%, and in one of the categories, I think it was business and industrial properties. Then we were told that we need the proposal from the cost of supply study was that we need to have a phasing approach for the next 3 years. But one thing that was then when we did that process, then it came back. The officials from NERSA came back and said that the contractor that performed the study and what the study said were two different things. So I just wanted to check with the officials from NERSA if it will be possible for us as a municipality and the guys from MISA to have a separate meeting so that we can be able to discuss that cost of supply study. Thank you, Chair.
Thanks, Nick. I was saying that on the next batch, I think it's my screen that is actually failing me. I see Days, I see Chris, I see Frank, I see Hilton. Who else am I missing? Colleagues, help me. Okay, now I think I have found a way to look at it. It's Frank, and then it's Donovan. Then it's yeah, I'm coming to you, and then it's Casey, and then it's Hilton. Yeah, I think I considered Hilton. So let's take those hands, and we will then take a response and do the other batch. Thijs, we can start with you.
Thank you, Chair. Thijs Moller from Swartland Municipality. First of all, I want to thank you for the workshop and clarifying the requirements and the new dates, which I do believe is much more realistic and fair towards all parties. I think in my history involved in the industry, it is the first time where I think there's a recognition that all pieces of legislation is important and needs to be adhered to by all of the parties, and not only some parties adhering to some portions of legislation. And then, Chair, a question really is regarding the public participation process in the municipalities. Normally, we also adhere to the PAJA process, which calls for 30 days public participation. So the question that I have is, with the submission and the checklist where you require proof of public participation, is the requirement that the public participation should have been concluded by the submission date of the 20th of March, or at least that the public participation should have started by the 20th of March. Because if it's to be concluded, it means that at least we need to go out sometimes before the 20th of February. And then also we need to provide feedback to the members of the public. So I think it's critical if NERSA can just clarify in terms of what the real requirement is in terms of proof of public participation. Chair, and then the last one is just a comment. I think the appreciation or the understanding that electricity is only part of the municipal budget and it forms an integral part of the process leading up to the final approval at the end of May for the municipalities. Thank you, Chair.
Thanks, Chris. Oh, that was Stace, not Chris. Then Stace. Chris, can I come to you? Chris? Okay, looks like Chris cannot hear me.
Sorry, yeah, can you hear me now? Am I audible?
Okay. Yes,
Sorry.
yes, proceed.
Thanks. Sorry, it's Chris Gower from Buffalo City Metro. Thanks again to everybody for the workshop. It's been good listening. But I've got a couple of questions. If I reference item 1 of the AfriForum NERSA judgment, NERSA are to submit the application by the 31st of August. So the first question, has Eskom submitted to this timeline? And the next point of concern is that you've had this submission for 3 months already. And also in terms of the judgment, you were to announce your municipal increase by the 31st of January. So I assume that they're doing an advanced cost of supply study, which some of the metros, including Buffalo City, have done. So you're going to have the advanced cost of supply study for 4 months before you announce the Eskom increase. Surely that time frame can be shortened. And also to follow up from what Prof. Folly said, you're going to do one cost of supply study in 4 months, and then you're going to do 178 cost of supply studies in 1 month. It doesn't make sense to me. Surely that time frame can be shortened, and hopefully the due diligence will take place with the Munich cost of supply studies. And also, is it an advanced cost of supply study that Munich must submit, or a simplified version of the cost of supply study? What is acceptable now? And then also, just to follow up from what Tice latched onto just now in terms of the public participation, also in terms of the AfriForum NERSA judgment, item 2.4, NERSA are to define the public participation process that Munich must follow. So can you define it for us? What is the process that we must follow? Thanks, Chair. That's all I've got.
Thanks, Chris. Frank, over to you.
Good morning, colleagues, and good morning, Chairman. Thank you very much. A number of questions that I have. I'm Frank Hinder from City Power. NERSA Council referred to 15.2, but I think we should be reminded that Section 15 has been amended, and when the Section 2.3, Section 15.3 and 15.4 subsections, which I think it would be appropriate that they be reflected on, because they seem to almost step over 15.2 in a way, and talking about 15.2, you cannot do that if we're talking about 3 and 4. On the latter, Chairperson, I think this is a workshop which...
Mr. Hinder, can you please clarify this question on the amendment? What is the essence of the issue that you would like to be clarified with regards to Section 15 sub 2, please?
Remember, the Council has said, speaks to 15.2, which speaks about NERSA roles around tariff applications and approvals. 16.3 says, notwithstanding 2, I can enter into a bilateral agreement. 16.4 seems to speak to issues around the market and so on, but can also which also says notwithstanding 15.2, meaning that the tariff approval functions can be taken out of NERSA depending on 3 and 4. 3 is actually talking about a deviation, which I can ask for a deviation to be approved by NERSA, and 4 is talking about things about bilateral, things about the market, and so on, which would then take the pricing function out of 15.2. And I think talking about 15.2, which we fully agree with, further referring to these elephants in the room, that it will not be fair and it may not give a full perspective to us, especially given what's been said by NERSA, who is the custodian of the era, of the Legislative Regulation Act, I mean. I hope that's clear, Chairperson.
Yes, we'll respond. I get it now.
Okay. On the letter and even in the presentation, it still doesn't come out fully that we at the municipal processes are depending on ERSA, and ERSA being an annual decision that needs to happen before we can, and it's also maybe the answers will deal with it, but we would have liked for ERSA to commit to the January date as prescribed by the courts around the ERSA. And if that is not possible, then we should have reflected on the knock-on effect it may even have on the municipal processes around that. To be quick, the letter, Chairperson, I think it's still warranted that letter be withdrawn for a number of reasons, because, for example, consultation and council resolutions are MFMA processes, and which have legislated timelines. And I would agree that the judgment doesn't speak to MFMA processes, maybe rightfully so, and we should therefore agree that a letter cannot then supersede the legislated provisions. But the letter at the same time says, if you don't give me a council resolution by 20 and proof of consultation, which has to be done, then it reaches that complexities that may have consequences as the letter stands. The number of legislative challenges that are happening are now going into the quality of the cost of supply study and the framework. And there is a pending judgment that seems to suggest that our cost of supplies may not necessarily be in full compliance with the EPP, particularly EPP policy position 1, that speaks about our depreciation and return to be based on regulatory asset base that must be valued in line, that must be based on a replacement value methodology. But EPP 1 also says NERSA shall determine a replacement valuation methodology after it has consulted its stakeholders, which then starts to say that, to the extent, and the EPP also talks up, to the extent that there's no compliance with the EPP 1, our cost of supply studies as we do them right now may well be challenged, mainly because they are based on the framework, and the framework appears not to be fully aligned to the EPP, as the court seems to suggest, and that has to do with the fact that, and that will bring us to EPP 1, which says NERSA must approve a methodology for asset valuation, and they must have consulted on that methodology. EPP 1 also says a return on asset is what we are entitled to, and the framework and the model and the supply studies that we may have submitted speak to a surplus, and the court may find that may be an alignment to the EPP. And maybe it is also time, Chairperson, that we have a proper methodology for municipal tariff approval processes, so that we don't appear to be making rules as we go along. Now, as a licensee, we want to fully comply to legislated requirements, to requirements that come from NERSA. But it is ideal that this thing be put up front and maybe after, in a form of a methodology after proper consultations, so that we know upfront what is the rule of engagement. and not get a letter in December that says so many things that now, yeah. And the last comment, Chairperson, is that given what people have said before, for NERSA to have from 20 March to 5th May and to comply with meaningful public consultation in the meantime is a tall order. Maybe 5th of June would be more appropriate timeline. I don't know what NERSA can do about it, but it seems very impractical to do so many municipalities in that 1 month plus 10 days, as somebody said earlier, while it would do no harm for it to be, at least to be done until 5th of June or 15th June for that matter. I submit, Chair.
Thank you, Frank. Let's then move to the last three hands, which is Donovan.
Thank you, Chair. Donovan Lewendahl, City of Cape Town. I'd like to start by saying thank you to the regulator for the opportunity. Things are looking promising. I think there are just a number of things that we need to just, if I can call it, polish. I'd like to echo some of the comments made by some of the other municipalities. I believe the ETSA is vitally important. It represents 70% of our costs. And we also need to, at the same time, understand what structural changes are being made. It's not just a matter of understanding what the percentage is. So, because that can have significant swings in either direction. So, it's not just the date of the 31st, but also understanding what is contained in that decision. From the city's perspective, the budget timetable is already set up from August the preceding year. So August past, we've already set up our budget timetable with council, with the mayor, and all of those different bodies, budget steering, budget strategy meetings, all of those things. There's also I want to call it interrelationships with budgets across the city because, as was mentioned also earlier, the different departments provide functions and so on for each other, HR, finance, etc. I'm also happy that there is acknowledgement of the MFMA. And that brings me on to, I want to call it the alignment of the MFMA, where the draft budget needs to be submitted 90 days before and then approved 30 days before. So typically, the city prepares a draft budget by the 26th of March, which is, call it 90 days before. So from our side, practically having a council-approved budget and tariffs by the 20th of March deadline is not practically possible. Our public participation process only starts after that, and that typically takes place during the month of April. And maybe the compromise there is that we can, in terms of the National Treasury single point of management accountability process, where we can maybe have our executive director sign off confirming that, this is going to be our submission to council in a week or two's time or something along those lines. Also important, and lastly, is just around the 5th of May deadline, where we as municipalities also require the reasons for decision. We cannot wait 90 days and then we go into the new financial year without understanding the reasons for decision from the regulator. Thank you, Chair. That's all from our side.
Thanks, Donovan. Hilton, and then we'll take Cassie, and then we'll get to the responses. Thank you.
Good afternoon, Mr. Matabula and your team. Let me just double check. Am I audible?
You are audible. Thank you.
Thank you. So it's Hilton Reynolds here. I head up the budgets for the Umdlatu's municipality, and have been involved with municipal finances for a couple of decades. So a little bit of a knowledge on the challenges we've been going through the last couple of years. So I must say, this is, although your session here is fundamentally around us getting some type of common ground in line with the regulatory environment to do with electricity tariffs. But I think it's going to help, given the number of people that are on this virtual platform, a better background to the complexity of tariffs and the budgets within the country, so we all get on the same page. So thank you very, very much for allowing us this opportunity and getting us together. So really, I had 3 issues. I'm just going to hit them all, but they've already been addressed. So hopefully, in your responses, you'll come to them again. But the big thing is, and I'm going to end off with the 4th one. So the 3 things are that have been addressed, and that is the MFMA dictates very clearly, together with the NBR, the budget process, and it is, and I'm glad you reminded everyone, it's a continual process, year in, year out. So we shouldn't be having any conflict in terms of timeframes, but obviously there are, and even the judgment itself is in conflict with the MFMA, which the colleagues have pointed out. So these are the issues. One is, in our case, the bulk tariff, and correctly so, the structure thereof, but the bulk electricity tariff makes up 60% of the cost. We don't even have that at hand yet, even though our budget process started at end of July, beginning of August. And we start with all the costs across all the services first, and we end off with the tariffs. So we need to have all our costs in place before we can end off with tariffs, and we don't even have an accurate idea of what the bulk electricity tariff is. So that's one thing we need to get sorted out, because ideally we're in a position to have a very rough budget by the end of December each year. But at this stage, we're sitting in a limbo with that 5.6 that was given us in the circular last year. But how accurate that is questionable. So that's the bulk tariff is the big issue. We need to work on that, on Eskom supplying that to municipalities well in advance, so we can help you. The second thing is, and I want to take the colleagues back to those that remember the days of the Reds intervention, where there was this big attempt to make electricity a proper utility service and ring fence it in 100% from local government there in the 2008 through 2010 period. And a fundamental flaw in that whole process, as laudable as it was, and as many billions of taxpayers' money that was spent on it, is that it ignored the role electricity plays in the municipality. It's integrated with municipal finances, not only from an economic point of view, but from an environmental point of view, from a planning point of view, from an engineering point of view, and of course, for people like myself in finances, it's very interdependent on all the other services. Yes, it has been abused over the decades from time to time, but I think with maturity, you learn how to not abuse a particular service that is your golden egg. In our case, it is, and with the guidance from yourselves and National Treasury and all the bodies involved in local government, the tariffs are, I think, fairly fair. But what we cannot get away from is the fact that it's interdependent of all the other services. You can't have rates without electricity and vice versa. You cannot have water without electricity and vice versa, especially if you're a municipality that's both producing your own water and purchasing water, your integration with electricity is in all respects, in terms of costs, in terms of secondary costs, and then of course the tariffs themselves, is very integrated. So we always need to be reminded of that. Then the third thing, and I think the colleagues already had mentioned that, the third thing was the issue of the conflict of the judgment, with putting you in a corner where you must now have the figures by the 5th of May. A discussion needs to take place between NERSA, COCTA, and National Treasury, and hopefully they're in the room today. And that is, most municipalities that are complying with the MFA are running their budget participation process from the end of March through to April, into early May. And the budget then has to be finally adopted at the end of May. Of what relevance? So the question is, of what relevance is the 5th of May to municipalities? Because we've already gone out in public participation with the tariffs, the proposed tariffs of the following year, etc. So there needs to be, and my suggestion is there needs to be an alignment. It's great that there's a court judgment because it's triggered. But what would be great is if there can be a high-level discussion with the National Treasury and COCTA around the alignment.
So sorry, colleagues. Can we please mute?
I think I got muted. I'm not too sure when.
Yeah, apologies for that, Hilton. I think they muted you instead of the person who was interrupting.
Do you know?
But you were still suggesting, you were suggesting that there should be a high-level discussion.
Okay.
So you can proceed from there.
Yeah. So that we can all have our processes in line with the MFMA, or otherwise the MFMA needs to be changed. So that discussion needs to happen between yourselves. Us as individual municipalities, even big municipalities like Cape Town, cannot unilaterally now, suggest this. It needs to be the collective of the country at a high level making those changes, because then we can, just sleep better instead of worrying about all these deadlines that are in conflict with each other. So that is a suggestion I wanted to make regarding the conflict of the legislation. That's it, China. Thanks again very much.
Thanks, Hilton. Cassie, can we take you last? Then we do responses, please. Thank you.
Yes, thank you, Chairperson, for the opportunity. I think, like the previous people said, that I think the important part is the approval of from our council, and then the positive participation of that takes up in April. So that is the thing that is bothering me at the moment as well. If you can give us good clearance, and then I just want to make on the previous letters that we received last year with the amount of tariffs that was at 5.something%, and then at the bottom it said additional 3 or something percent can be used. Can we use that 8.76% then to work out our new tariffs? Or if you can give us some directions on that as well. And then I just want to ask you, I think we are ready to submit our application, but it's just that two parts that says that we need to have a council resolution and participation. But that also will just happen next year. I think we've got in January or February, early February, late January, we will have that. So yes, is it necessary, if you can just give us the feedback on that, because like we are ready, our cost of supply, like the others is already last year we handed in our cost of supply, so we got a study that is applicable, and there's no structure changes that's coming from our side. So if we can roll that out of the way, then we can, as early as in January, like you said, the 16th, but I see it changed now to March. we can submit ours as soon as possible.
Thanks, Kasi. You said you're from which municipality?
I'm from Saldanha Bay Municipality, Western Cape.
Saldanha Bay. All right. Thank you very much. We appreciate colleagues. Thanks for the inputs. I've seen comments that were coming through requesting that presentation be shared and emails be given. We will certainly do that. Ms. Masetti, to avoid me being the referee and the player, can I request support? I'm not sure whether it's going to be yourself or Mr. Murati starting.
I think I can start. I think all of us, we can just assist so that, because this is really a workshop, I must just, excuse me. I must appreciate all of the issues that were raised by the speakers. And I'm hoping, as I indicated, that this is not the only engagement that we are going to have. Already from the questions that you have asked, for me, it is apparent that there are still some issues that needs to be resolved. The situation that we find ourselves in, yourselves as municipalities, as well as the regulator, insofar as the misalignment on the timelines is a critical issue. So in as much as we'll also engage with the relevant departments, the National Treasury, for instance, and the Minister of Finance, insofar as the statutory timelines that are in the MFMA is quite critical, because the court has put these orders without the opportunity of those that are given the powers in FMMA, Financial Municipal Management Act, to have an opportunity to indicate whether these orders are going to be practical or not. They have not been heard. So that on its own presents a challenge. Because again, the issue that was brought by AfriForum before the court, it seems to me, insofar as these orders are concerned now, it goes beyond the issue that was brought in there. But I'm not here to talk about what NERSA is going to do with the judgment itself, and what the municipalities themselves, when they find that these things are impractical and are going to bring some, they're proposing changes that are not in line with the legislation that the municipalities are required to comply with. So we do find ourselves in that situation, and we cannot leave that situation the way that it is. So first of all, the judgment does not speak to any finding that the provisions of the MFMA are unconstitutional. It has not pronounced on that. It has not made any findings. One then asked, you ask yourself as to why would then the court pronounce and deviate from the timelines that are prescribed in the MFMA, Section 43 in particular, in Section 43 in particular. It is an issue. It is an issue that we may need to look into, and also when one has powers to pronounce, such as the Minister of Finance, because he's the one that has the discretion in terms of the MFMA, was not in court, was not the party in the proceedings. Yet there are findings or certain court orders that that party must now comply with without being heard, insofar as whether such orders will be practical and enforceable. So that again is an issue that we'll need to talk about, so that at least we can provide a clear direction to the industry regarding the timelines that are going to be followed by the industry. So I think this is now at the beginning of these engagements with the industry, starting with yourselves, but then we must also make an effort to make sure that the National Treasury participate actively on this. And also we will, from our side as a courtesy, also just inform the minister with regards to the timelines, because every year when we get applications late, we then have, as NERSA, without municipalities going themselves to the Minister of Finance, because we were respecting Section 15 of Section 43 of the MFMA with regards to the date of 15th of March. So what we have always been doing, we would then go to the Minister of Finance, request indulgence, so that at least the municipalities, that we can still be able to evaluate the applications of the municipalities, so that municipalities can have tariffs by the 1st of July. That's what we have been doing. That's why the court itself indicated that NERSA has been accommodating the lateness and therefore make late decisions. So it's also important this time around, when there are changes, that we also inform the minister. Now, what do we do this year? In as much as there are these inconsistencies with regards to what the judgment is saying and what the MFMA is saying, given that now, even if there were to be, the judgment is taken on appeal or so, but now we are stuck with the deadlines and there is no time. Then the issue of the 20th of March only comes in because first of all, I must clarify that we do not have an application from Eskom at this point for the ERSA. We don't have that application at this point. As you also know, that sometimes that application comes late. We will usually receive that application around January. Now, you know that because of the judgment delivered yesterday, it states that such application must be received by NERSA around August. So we will then expect that application only in January. And Professor Valley, you stated very clearly, because there's a lot of things that the energy regulator is doing right now, given the transformation that is taking place in the industry. So we are therefore duty bound to make sure that that application will follow due process in terms of 30 days of consultations. And we must also make a decision before 15th of March. We have always complied with regards to that, because Eskom will submit in March, and then we have to try by all means from our side, even though we receive sometimes that application late, so that from our side, at least we make a decision before the 15th of March. So then if we manage then obviously to take the decision before the 15th of March, it means now we must now expect the municipalities to submit their applications at least by the 20th of March, because we don't have much time. And even these 40 days that we have, it's actually not enough, because 30 days must be for the consultations. So we find ourselves in that difficult situation. And the ideal situation would have been where if they want us, then if we stick to the 15th of March, as in terms of the MFMA, we would expect that applications come even earlier. Then we have the date of the 15th of March. But we don't know because also the FMMA, it says that if applications are received after 15th of March, then the tariff will not be applicable in that financial year. It's stated in the law. How do we deal with that? And these are the kinds of things that I thought you would also just share your views here, so that we can see how we can work together You can also get a better clarification. Yes, we'll also include I was hoping that the National Treasury officials will be here, but also I think they will also want to have a discussion with their principals from their side. So we find ourselves in that situation. In as much as the court says NERSA is a creature of statute, it needs to comply with the other laws. Now, if we comply with the other laws, how do we deal with the fact that Section 43 says that we must make decisions before 15th of March if the tariff is for that same year, by July of that same year? If it's after 15th of March, then it will apply for the other year. So how do we deal with this, given now the judgment that has been delivered? So these are some of the things that we need to clarify, so that also from our side, in as much as the court now says, let us put out there for private distributors and municipalities how the process is supposed to be. How do we deal with the issue of the process when there are actually conflicts with what this law says and the fact that there's not been a pronouncement on the unconstitutionality of the MFMA? So these are some of the complexities that we need to navigate around them and consult also other bodies. And I thought that this is quite critical. And so that we know by now, yes, there's going to be some changes, but are these changes going to be permanent now, given what the court has said? And what then do we do? Is Section 43 of MFMA invalid, legally invalid now? Must we ignore it and take what the judgment is saying? And if for this year, just to manage the process of 2026, 2027, maybe because there is no appeal on the judgment, we may need then to stick to the timelines of the 5th of May. Because there is nothing else that has been said at this time. There is no appeal of this judgment. Yes, obviously, it was delivered yesterday. I'm hoping that I am clarifying this, because whatever process we are going to embark on for 2026-27, it might not be the final process until these inconsistencies are clarified, and also we understand whether the Minister of Finance is also comfortable with the timelines that are now imposed by the judgment, and therefore which timelines are now sort of taking away his discretion that is in Section 43 of the MFMA. We still have those things that are hanging, and which we need to make sure that they are also brought to the attention of the Minister and the National Treasury, as they were not the parties in those proceedings, but the remedies and the reliefs that were then granted are reliefs that are affecting the powers of the parties that were not in court to be heard, whether such orders will work for those parties. Those are some of the complexities that we need to look at. So whatever we're going to do for 2026, 2027, just to provide a guidance to you now, might not be the final process that we need to follow until some of these things are clarified. I would like to stop here. Mr. Morati, you can take over. I just wanted to just clarify that part, and then I will come in on the other questions.
Thanks, Madam Masset. Probably let me start with the issue that Tace has raised, the proof of consultation. The appreciation being that there are two consultations that we are faced with. One is a consultation built into the MFMA through the budgeting process, and that provision, when you look into it in terms of what it compels the municipality to do when doing the budgeting process, it generates that requirement to say the municipality must consult, and one looks at it from a point that a budgeting process is a construct, and it being a construct, the building blocks, Umuchiza talked to it in terms of the separation of the building blocks of the budget, and looking into it that the provisions of the MFMA says the municipality in the introduction of the budget, there's a component relating to the consultation component. And in that consultation, that is between the municipality and its residents. That is in terms of Section 23 of MFMA, that these are the institutions, these are the people and institutions that could be consulted. And in that first phase, one says there's a provision that talks to consultation with national organs of state, which NERSA is one. One can say in that consultation phase, if appropriately constructed, NERSA could be factored into the requirement of consulting. The second part of it is the issue of information that the municipality, in terms of Section 24, there's a requirement that within the 30 days before or the consideration, there are certain sets of requirements that have been built in. So that is the first proof of evidence that one would say the municipality has published the budget, and this is the proof of it, that it was published for stakeholder consultation. The second set of consultation, therefore, is the one that Pajap now places on NERSA to say you have to do the consultation. But the interrelation between the two is that the very stakeholders who will be consulted through budget process, they will be consulted through tariff process. And there's also again an aspect that Muchiza has touched on, in that in the whole phase of budgeting, the municipality can consult on the issue of electricity because it needs that now when it goes to the approval period of the municipal council. It goes now recognizing that we have finality on the side of electricity, like any other services that gets to be dealt with by another organ of state that approves that. And MFMA. So MFMA has the whole structural interface, structural considerations that must be made when the budget is being built up. Comes in the issue that, again, that Chairperson, the issue that Mr. Hinda has raised, which is just an interpretation, unfortunately, that the default position of the Electricity Regulation Act is that NERSA is the custodian of that framework. So therefore, the issue of licensing, tariff approval, and enforcement, NERSA becomes the first person to deal with those issues. But an exception created, and Mr. Hinda referred to 15.4. 15.4 is an exception to the default of the reading of the Act, that if an activity arises from the competitive bidding process, the competitive bidding process which is found in the market has a life of its own. Therefore, we wouldn't be having this conversation if the issues related to that, because it will have a life on that other side. So we are on this side where we're dealing with the issues that Section 15.2 and 3 deals with those aspects, and 3, the negotiated pricing agreement that comes out of, or the so-called bilaterals. You would have to deal with them having consideration of what the interim rules that the department has published provides for. You'll have to take cognizance of what policy position 14 of the EPP provides. And all of them combined, they still come back to say the regulator must approve. So the issue of approval, the tariff, or the issue of the bilaterals, the regulator is entrusted with the power to approve those issues. I think for me, the effect of the timelines, Madam Maseti, you touched on it, and I wouldn't want to repeat. The issue of the judgment vis-a-vis the law, two issues comes to mind, and one is that the judgment has not created a grace period, as I said earlier on, therefore, meaning the judgment becomes effective immediately. But how does the judgment become effective immediately when it didn't pronounce on the invalidity of the law? That deals with some of the issues that colleagues are raising. One would say we import the provision of the rules of the superior courts to say all the parties involved or any can approach the court to say, can we be assisted in terms of how do we progress with this, because there are these issues of conflict that we are not sure how to navigate through. That is not a challenge to the decision. It's a clarity seeking that the court can provide guidance. Otherwise, in the effect to avoid contempt of court, we are stuck with the judgment. We'll have to comply with the judgment. I think on the issues that are needed to deal with, Madam Maseti, I would hand it over to the chairperson. Thanks.
Okay, let me quickly, thanks Mr. Morati for that. There are questions regarding the deforms, and I think it's an important question in the sense that sometimes when the deforms are used, the information is outdated. So the deadline of the 31st October, is it a final deadline, or can they still submit information? I will say that they must still submit information that, an updated data that will assist the regulator, as opposed to just be stuck on the deadline of the 31st of October, because in any event, the deadline now is going to be March anyway for the municipalities. So I think it will assist us if you can update the information that is in the deforms, because we would like to get the most updated and recent data to work on. And this will also assist in terms of those municipalities that have not submitted their deforms, because we are sitting at 64%. Please, again, let's take that spirit that says that let us not be reminded about what we are required to do. Let's just comply. So I am hoping that at least this 64%, as we get into February, it will improve significantly. And also the data that is uploaded on the deforms, it will be the useful data that is updated. The issue of us requiring at least something that shows that the council supports the proposed tariff. It's important. Why it is important is because we have been challenged every year. There are letters that come to the regulator where, they would claim that there's an official within the municipality that did not have the authority to have applied for a particular tariff, and therefore the council has only approved or authorized this much, and therefore the one that was applied for is not what the council has supported or proposed. And we receive not only in one municipality, on a number of municipalities. Even this year, we do have that. And some of the things that we have also seen is that the municipality also indicated members of the council, some individual members of the councils in different municipalities, indicating that Some of the tariffs that were approved by the municipality as proposed tariffs did not include fixed charges. And now the tariff that has been approved by NERSA include fixed charges. We obviously would not add anything that the municipality has not applied for. So we find ourselves in a situation where we have applications that will include things that the council will then distance itself, some members of the council, that write to NERSA to challenge why the tariff is the way that it is in terms of what NERSA has approved. So that is the reason why at least we need the authority there to see that the person who applies has that authority and that the council would have at least proposed that tariff. We understand the issue of the timelines now, that you'll say that, oh, well, that council can only sit when and when. But just understand that now is still an issue that all of us, we still need to deal with. But as of now, just to assist us in doing things right for 2026, 2027, let us see how you could at least facilitate for the council to have a look at what will be brought to NERSA. And also from your side, you must also make sure that at least you have a way of informing your customers as to what tariff you are going to propose to NERSA. I think that is important. From your side, we will not dictate, but it will be your own duty to consult from your side. From our side, we will start consultations once we receive the applications, at least by the 20th of March. That's when we will start our consultation in terms of the law from our side. And then the other thing that, and I'm dealing with some of the questions that were asked by others, but also by Usolani Zanyane. So if also we can just look into the dependence on, I think I've dealt with the issue of the dependence on ERSA, and that ESCOM was not party to the proceedings, and also the National Treasury was not party to the proceedings, but we will also find a way of also engaging with them and ESCOM so that we make sure that the information on ERSA is available for the municipalities to be able to prepare their own applications. We take note of the fact that the 40 days is quite a challenge. It's a challenge if also it's not business days, because NERSA works on the basis of business days, not calendar days. I mean, there's no one who comes to the office over the weekends and do work. And we also don't count weekends when we calculated the time periods, even for licenses and so forth. So that on its own is going to be a challenge, because it reduces the number of days for us if it includes weekends and perhaps even public holidays, if we're talking calendar days. So really that is going to be a challenge for us. And those are some of the things that we also need to raise as practical challenges for the energy regulator. We take note of that comment from your side. With regards to I think the issue of the cost of supply studies, you would note that in the decisions that we have taken, because some of these cost of supply studies came late, we obviously did not have sufficient time to thoroughly scrutinize them. Hence, we only said we note them, so that the costs that are there are the costs that have been used by the municipalities to then come up with their tariffs. So that was appreciated. And NERSA also assisted the municipalities in coming up with the cost of supply studies. But two things about it. Yes, there's an issue of inconsistencies with the electricity pricing policy. It's an issue that we need to work on. We will deal with those things, how best we can deal with that, because I'm sure the EPP also is being changed. Now, as we understand it, the department is busy with the revision of or the review of the EPP. So let us also look into that carefully, as we also looking at the refinements in the cost of supply studies, but comply with what is in place at the moment, because there is no final revised EPP. So let's comply with what is in place right now. The second thing about the cost of supply studies, the court had said that they must be published as well as we publish the applications for tariffs from the private distributors as well as the municipalities. So we raised the issues of confidentiality there, but just think about it. If there's any confidential or commercially sensitive information that you would like us to take note of, as we please let us know. I mean, in terms of all of the municipalities and private distributors, so that we can be in a position to consider that. I think we also talking about Mr. Marathi. I think we dealt with the issue of, there's an issue of advanced cost of supply studies and simplified cost of supply studies. No. On this one, I've already explained. SM, you didn't raise your hand so that we can all listen to each other and give each other an opportunity to speak. If you can just mute yourself. So the issue of the supply studies, I'm saying that we can have another engagement later on just to look into those issues and how we can provide guidance and what are some of the challenges, even from NERSA's side, in the way that they have been done. I think we can have another workshop there so that we can take some of the key issues on the cost of supply studies and assist further. So we can maybe park that one. I think Mr. Marathi already indicated the issue of Section 15.2. Really, that one is about the market competition. We're not even there. So the NERSA's limitation in terms of approving tariffs, we don't have such a competitive market at this point in time. And the issue of deviation, you deviate from the tariff that has been approved by NERSA, and there must be reasons and for such deviation and so forth. And then the issue of us withdrawing the letter, I don't think that is necessary for us to withdraw any letter, because we even indicated that we had the parties, and that is in any event overtaken by events. So we even extended the deadline to the 13th. However, with the judgment that came out, which we also explained today, what it says and some of the challenges, we are saying that, yes, for now, there's no grace period. We will follow what the judgment is saying, whilst we are addressing some of the inconsistencies that are there with the laws that are in place. So there is no need of the letter. We just clarify to the parties what timelines now we are going to look at, which are the ones that are stipulated in the judgment for at least 2026, 2027. That shall be the position on that one. There's no confusion, at least in terms of that. So we will follow that until further notice. And I think the other thing is that until we engage other parties and find and get an understanding of how are we going to deal with the inconsistencies, maybe at that point, it is only at that point that NERSA will be in a position to then provide a process that will then be followed by the municipalities as well as private distributors in terms of the applications for the annual tariff applications. So maybe only at that stage that we'll be able to do that. I think all of the other issues have been raised, and we responded to that. Maybe one of the issues that we would like to flag is that for 2024, 2025 tariff applications, you will also note that There are issues of clawback and give back, which needs to correct under recoveries and over recoveries. So we can only do that once we receive the audited financials from the distributors. So we are waiting for that. We couldn't do it this year because the financial year end of the distributors is 30th of June. So we expect then to get the reports that will give us the opportunity to assess the recovery of the tariffs and then what happened. So we still haven't received such information so that we can see where are the under recoveries as well as the over recoveries and what were the reasons. So I would like to flag that so that we can be assisted by all of the distributors that are here to submit that information to enable us as part of the decision that was taken to be able to apply the clawback or give back. Please assist us with that. Lastly, you will note that for the municipalities, certain municipalities in the decision with the challenges that are experienced by municipalities, the issue of the collection rate, the issue of illegal connections, and the revenue or financial situations of the municipalities, we have put certain requirements for improvements as allowed by the law, that we can set performance targets as well as ensuring improvements by the licensees. So we have stated such improvements, what areas they need to improve on, and therefore submit reports after 6 months. We still have not received those reports after 6 months. So would like to remind you, if you can assist the energy regulator to do what it is required to do and assist, so that you don't again come only at the time of the applications. Then we again see the same situation, no improvement, or the situation has become worse. So if you can kindly submit the 6 months reports as indicated in the decisions that we made in respect of all of those municipalities that were affected. Thank you very much. That's all from my side. Mr. Matebula.
Madam Maseti, thank you very much. I appreciate that extensive response. Maybe let me just touch on two issues, then we will move on. I don't see any hand at the moment, so probably we'll have to close, but I will talk to that. There was a question on public consultation on whether it should be concluded by the time the application is made, or should it have started? And I need to use the opportunity to explain the purpose of this consultation. It is important that the municipality should have engaged, informed its customers in terms of what it intends to apply for to the regulator. So if half of the people know and half of the people do not know, then the purpose of consulting it's null and void. So it is important that the people that are going to be affected by the decision are aware of what is it that you as the municipality have submitted to the regulator, and we as the regulator do the same activity by informing society of what is it that you have put before us. So we don't want your people to know from us on what you have applied for. It is incorrect. So it is important that we ensure that consultation in terms of the municipal tariff is concluded before the application to the regulator. And the council, I have taken the guidance in terms of the fact that it is council supporting the application. It is not approving. The approval is done after. So we have taken note of that. I want us to do the closing round of comments. And then I will allow Ms. Maseti and Mr. Murati to have also their closing remarks after, and then we can certainly close the session. And there was a request from Emma Kazeni for a meeting outside this meeting. Yes, it can be arranged. Let's engage outside this meeting. We will be able to support you. And that goes for anyone who may want to engage on anything afterwards. So I see there is a hand from Vali, Frank, and Nombulelo. Let's go in that order. Thank you.
Yeah, Chair, thank you very much for this session. I think it was an excellent session, given the responses and all of that. But there's one aspect that I want to take this opportunity of raising it. And I've been raising this matter a number of times over the last couple of years, actually. And I put this on the chat box. It's a very detailed question, but I'll talk to it, which I think needs to be addressed now, actually. I don't mean in this meeting, but it needs to be, well, we can talk about it, but maybe NERSA and maybe in consultation with government, but definitely in NERSA. You know, NERSA's role is inter alia, notwithstanding the pronunciation on tariffs, but affordable. So NERSA has a balancing act in terms of the act of the law. And for many years and many decades, and I've personally been there in the space for many, many decades, is that NERSA, and I'm not saying there's anything wrong with NERSA, they are executing their mandate in the context of the balancing act. But in the execution of that mandate, which they also have a mandate to protect all role players along the value chain, including ESCOM and the municipalities. And as is common knowledge, for many, many decades, but especially in the last few years where the tariffs have gone through the roof, especially from the ESCOM side, municipalities, and of course ESCOM has been arguing the same point, we've been not getting generally, and I'm talking about prudent, cost-effective tariffs. I'm not talking about the inefficiencies and all of that. So I'm talking about where there's genuine, prudent, cost-effective tariffs. The regulator, rightfully so, in the context of their mandate, Balancing Act, always defaulted to a lower affordable tariff to the cost-effective tariff. Because of recently the tariffs have gone to the roof the last 10 years or so. Now, it's going to happen again. So we're going to all comply. Hopefully, we're all going to comply with the deadline, the timelines. NERSA is going to do the tariff applications by 5th of May, I think it is, and all of that. But we could end up, I'm talking about the municipalities, with tariffs that's not going to be cost effective again, right? So how do we address that? Because now we are going to be back on the back foot. In other words, municipalities will be further exacerbated in terms of viability and viability meaning cash flow and capex, opex, investment on the grid. And we are in the midst of looking at industry restructuring. I know the gentleman from Cape Town talked about the ring fencing. I know I was there at the time when we looked at that, at the initial restructuring. That's a valid point. It's a sore point. It's a sensitive point. It needs to be addressed. I agree with that. But I think the point I'm making, Chair, we have about 500 people on this platform. I think everybody's grappling with this question. I think how is NERSA going to address this? Maybe a principal viewpoint from you, Madam, Musoti. But I'm comfortable that you're taking it forward. But I know government is also addressing this, the ministry. But the point I'm making, I think, is there has to be a middle ground. How do you harmonize, rightfully so, affordable tariffs? Otherwise, it will kill the economy. But how do you, at the same time, don't throw the baby away with the bathwater? How do you ensure that Munich and ESCOM are still sustainable so that we can execute our mandate, which you are overseeing as NERSA, that we offer a top-notch service delivery at the lowest, I would argue, least possible cost. When you accept the cost-reflective tariff, when we submit the application, and then you say, sorry, we can't give it to you because we've got to go to affordability, which is your role. But how do we address this? I mean, I think now it's time we've got to put this back, we've got to put it on the table. We've got to deal with this front and center. Otherwise, Munich will disappear. ESCOM will also disappear. Because any business, I mean, private sector won't allow this. I mean, the CFO won't go to the board and say, sorry, we charge below tariffs. That will never happen. So I'm being blunt about this, and I'm putting it on the table as the AMAU strategic advisor. And I'm back to you, Chair.
Thank you, Prof. Frank?
Thank you, Chairperson. Maybe just 3 comments, Chairperson. It is, we had a 2-hour meeting, and it then becomes, what is this, the word? And unfortunate that we agree in the conversation, but our conclusions then still stand. After we have been in the conversation agreed, for example, when we talk about the consultation process, we seem to agree in our conversation that it's a MFMA legislator driven process, which has got a legislative timeline, and in terms of which 20 March proof of consultation is not viable. We agree that, but then we still say that we must still submit. And then it makes it very unfortunate that we consult and talk to each other, take the input, and then simply ignore it. At least that's the impression that we are creating if we say that you must still give proof of consultation on the 20th. That's one. The issue around the clawback, for example, Chairperson, maybe it is time that NERSA develops a municipal tariff approval methodology so that we know these things up front. We just get a letter that says it will be done, but it's in a vacuum. We don't know what is the rules of engagement. More importantly, Chairperson, unlike in the case of ESCOM, when NERSA has a revenue agreement with ESCOM, NERSA, for example, says that for the next financial year, ESCOM will get 409 billion by increasing the tariff by 5.36%. For example, that's a letter that was written to the ESCOM CEO and was an undertaking between ESCOM and NERSA. There is no such letter between NERSA and City Power. We only have a set of tariffs that have been approved. And then we get a letter that says, talks about clawback, but there's no revenue undertaking that was done in terms of written undertaking between the two parties. The same example about the EPP policy position 1, Chair. We agree in the conversation here that there needs to be alignment around that. But at the same time, I'm sitting with a letter that says that I must apply, my tariff cost of supply must be compliant with EPP 1. But we agree that EPP 1 says NERSA must do certain things upfront. And in the conversation, we seem to appreciate that fact. But when we say the letter stands, it then dismisses what we have agreed. I mean, if I have to put it as blindly as possible, I submit, Chair.
Thank you, Frank. Nombolelo.
Thank you, Chairperson, and again, thank you very much for the fruitful discussion. And as Mama Seti has indicated, this is one of many to follow, which is also appreciated. but we are confronted with the reality of the deadline for the 26-27 financial year applications. We appreciate that the letters that were issued are not going to be withdrawn, the ones that were depleting the deadline of December and then January. Now we all know from this discussion that it is now 20th of March. And we would want to adhere to the requirements because, as again Mama said, is indicated that non-compliance by the utilities would be the issues around the municipalities not being able to have the correct tariffs. There is motivations, or there's an expectation from the principals, or at least my principals, after this discussion, where I need to feedback and also map a way forward so that we can comply, so that we don't find ourselves wondering. Apologies if I did not get it, but just for my simplicity, the two aspects that are of importance as we were talking that I'm realizing that I might be challenged, or we might be challenged as Stellenbosch, is the issue around a proper public participation, especially when the chairperson indicated that if you communicate to 50% and another 50% of our customers don't know, then that cannot be deemed as a proper consultation, and I agree. And I think the measure that the municipalities normally have to prove that they've done their part, whether people came or not, is through the IDP processes where it's advertised timeously and it is sectioned by various zones in terms of the wards. Then if people come, they come. If they don't come, they don't come. But at least that is deemed as sufficient effort from the municipality to do a public participation. But in this instance, we may be challenged to facilitate that process considering the time frame. And I'm not even sure if you can do that public participation only for the tariffs or electricity. What would be sufficient, at least for us to submit? Would it be notices? Would it be the fact that maybe we propose to council, maybe that could be arranged to say, let's have a council meeting and motivate to the principals. But what would be deemed that if Stellenbosch submit the tariffs would be deemed as compliant to say that you have ticked the box that says that one of the requirements is for you to do public participation? And secondly, the issue around the bulk purchases from Eskom that we don't have the tariff for, which in our instance, for an example, the cost reflective tariffs as per our cost of supply are ridiculously suggesting ridiculously high increases, which we are then able, through the bulk purchases that we know would be this much, we would then be able to see that we are able to bring them down to a part where they are a bit affordable, but also not placing the municipality at a risk. So the question, therefore, that I'm asking is, if for some reason there is no application by the deadline for Eskom, what happens? Does that mean also for Eskom they will be in the same boat as the municipality, that there will be no increase? What is it that we can feedback to say that it would mean this? Or if then there would be further consultation, what does that mean in terms of the prescribed deadline? Thank you.
Thank you. The last hand is from Zolani. Zolani, can you hear me?
Yes, I can hear you. Thanks for that.
Awesome.
Also, my appreciation, as I've indicated, even Ella and other speakers, to the regulator itself for this particular workshop, given all the, I'll say, the evolution in the pricing regime of electricity. One, I'll say advice that I would offer, it might work for some, but not for some, specifically on the development of or review of the cost of supply studies. Rather have a phased approach because some of the input information where it is already available, it will be best to start with the process rather than to wait either for the end of January or subsequent to that to actually start the process. It will then make it easier just to factor in new information that will be coming in at that point in time to ease the pressure on your side. Yes, on the budgeting process and cycle, Chair, as indicated, it's a broader discussion, as also committed and proposed, firstly by the regulator, but also many of the speakers, that there is a need to engage other role players, your National Treasury, your COPTA, in terms of ensuring that alignment. But again, in terms of public participation itself, ideally, it's not something that is confined to the IDP together with the budgeting process. We just need to find innovative ways of how do we then build in this emerging change given the tariff application process to the broader public participation processes of municipalities, because with the Municipal Finance Management Act and its processes and deadlines, trying to align with the court judgment itself, that alignment we might not necessarily achieve for the current process of 26-27, but where an opportunity presents itself for a public participation to take place, then I think that must be considered. Thanks a lot, Chair.
Thank you. Dace and Chris, you will be the last hands, then we'll get the final response. Chris?
Thanks, Chair. Just to follow up from the last two speakers on public participation. Okay, so when we received, or from Buffalo City's point of view, we went out on a public participation drive. We put adverts onto our website. We sent out 55,000 emails to our registered customers on our billing system. And we sent the cost of supply study that we had completed. We did the tariff comparisons, a spreadsheet, how it's going to affect the customer. Those were all sent to the customer. So we did all that process. And what came back out of that process is that the customer wants participation in the verbal debate on the tariffs. So the IDP process has to be taken into account. I think Frank suggested earlier on that we extend the deadline for NERSA to consider the cost of supply, the municipality cost of supply studies until the end of June, I think it was. And if you do that, you will allow the IDP process to sort of unfold and to have some sort of public participation on the municipal front through that IDP process. So you're going to actually help with the
Chris, you done or did I lose you?
I'm done, Chair. Thank you.
Okay.
We missed the last part
Dace?
from Chris. I think we missed the last part on the
Did
IDP
you?
process.
Okay, sorry. Let me just start again then. Okay, so Buffalo City, we've already gone out on a public publicity campaign. We've put adverts onto our website. We sent out 55,000 emails to customers who have got the email addresses on our billing system. We've responded to about close to 600 individual emails at the moment. And all the 55,000 emails that we sent out had our new cost of supply study attached to it. It had tariff comparison spreadsheets of how it's going to impact the customer. Those were all attached to it. But what came out of that whole process is the customer actually wants a verbal debate on this process. They want to be part of the IDP process to discuss this in person, and they want to have that opportunity. So I know Frank earlier on suggested that we extend your process to the end of June, I think it was. And if you do that, you'll have a couple of more months to do due diligence on the municipal cost of supply studies that you won't just have a month to do it, you'll have a couple more months to do that process. You can also publicize it a bit longer and allow for all those public comments to come in from those IDP roadshows that the municipalities will hold. So it's a win-win for everybody if you do that. Just my suggestion. Thank you.
Thanks. Dace, let's have you as the last person. Thank you very much.
Thank you, Chair and colleagues. Just once again from Swartland's side as well, appreciation for the session today. But just my last question or request is whether NERSA would be issuing a statement or a short summary based on the discussions and the new timelines as agreed, so that it can be shared with all municipalities that might not have been able to attend, and we can use that as a briefing back to our council members via email as well, because there's definitely not going to be additional council meetings during this month, but it would certainly assist if such a summary can be made available. Thank you, Chair.
Noted, Chris, Dace. Ms. Masetti, I'm going to hand over to yourself and also to do the closing remarks for closing the session. Thank you.
Thank you very much, and thank you to the participants for the additional questions. I think all of us, I think we must recognize the fact that we are challenged by the new timelines that have been imposed by the judgment that was delivered yesterday. I think it's important for us, and I don't know how much we can actually overemphasize this. And we are also recognizing that those timelines are not consistent with the timelines that are prescribed in Section 43 of the MFMA. So that's the first challenge that we have. And then we are saying, how do we deal with that? Must we ignore what the judgment is saying? And we have said that obviously not, and also because that judgment does not even give us the grace time. So even the proposal for June, you see, if we were doing what we have been doing all along to accommodate and also ask the Minister of Finance to indulge us by giving us a date, just like we did this year, we were required to complete the process in May. We then said, if we complete the process in May, and we're talking about the practical situation here, we said it will be impossible. And look at the far-reaching implications for those municipalities who have not yet submitted their applications, but even some that have submitted the applications in May, we still need to consult. So if we're now given a deadline at the time, not this one, at the time the Minister of Finance said, NERSA finalized the process in May. And we said, we received the applications late. Some of the municipalities have not even submitted. Then we requested the municipalities, because we're accommodating the municipalities. We could not even come back to the municipalities or to say we are given this deadline, but we understood what challenges you would have. Then we took it upon ourselves, and our chairperson had to write to the minister, persuade the minister to give us at least until June. Then minister gave us until the 20th of June. That's when we managed to process all the applications for all the municipalities. Now, with this judgment of yesterday, it is taking us outside of that process that is prescribed in the MFMA, where we have the 15th of March, and then we say, Minister, we understand that this is what this says, but you've got powers. Can you please give us some additional time? Because the municipalities need to do this and do that. We also wrote to the minister that is responsible for COGTA to advise that, yes, you must appreciate that sometimes some municipalities have certain challenges. Because of these challenges, they've not managed to submit to us. Can you please indulge us? And when you indulge us, you actually indulge in the municipalities because we want to do what we can to assist them. So now the court is saying that issue of us accommodating the municipalities, it makes us not to comply with the laws. Now, how do we then extend to June when in fact both the MFMA does not take us there unless we ask the Minister of Finance, right? So that's what we'll do. So we are unable to go to June on our own as NERSA. We can't even promise. We will have to request to the Minister the same way that we used to request all along. But if this year we want to do that, how? When the court has dealt with that extensively in the judgment. I think if you go, I can't remember what paragraphs are those. But in the paragraphs of the judgment delivered yesterday, the court dealt extensively with how NERSA has been doing this, such that then it results in lateness. Those were the words used, terminology that was used, and secondly, the delays. Now, the judge said, now this means that NERSA's decisions are late, and therefore we cannot allow the body such as NERSA to make late decisions when the laws are not allowing that. That's what is in the judgment. And then the judgment again gives us separate deadlines. Mr. Hinder, we will have to comply with the judgment so far. I made that point. I don't know maybe how best I can actually articulate this. I had said that we have timelines prescribed, and you acknowledge that point as well from your side. We've got the process and timelines that are prescribed in the MFMA, Section 43. So that's where NERSA finds it's at least try to align its powers of approving tariffs, and we align ourselves with Section 43. However, now that timeline that is in Section 43, the judgment ignored that timeline. You yourself also made that point very clearly. So now it puts a different timeline. And I'm saying even ESCOM was not aware that now it is required to submit to NERSA in August. And I even said such reliefs that are then imposed, these reliefs are imposed and affect other parties that were not part of the proceedings that were initiated by AfriFora. They didn't participate in the courts. They didn't have an opportunity to say these things will be impractical. But what is NERSA supposed to do? Is NERSA supposed to ignore the judgment? Obviously not. It's another risk. So we don't want to be found to be in contempt of the court and the orders of the court. That is the issue here. So it is not a question of saying we discuss something and therefore NERSA is not taking the input. Remember, I said this is a process and an engagement that we want you to also to have an appreciation of the legal risk and how we can navigate around this legal risk. But as of at least 2026, 2027, because there's now no appeal or leave to appeal that is before the courts, what is now before us? We're stuck with this judgment for now. And there is nothing that we can do. We're sitting in December now. So we can't do anything. We can't ignore that judgment. So it means the date of the 5th of May stands for now. And this is exactly even from my opening remarks to say, we don't even have some transition here, period that we are given. There is no grace period. Now, this means those orders by the court will have to be implemented immediately. And I said, that's the challenge that is facing all of us. Do we like it? We obviously don't like it, because also it limits us. And also it limits even the time that we could take. Look, it means now NERSA must put everything, when we receive those applications on the 20th, we must act quickly to publish them we don't have time. There's also calendar days. How are we supposed to put resources to deal with this and make sure that all the 178 municipalities, they are thoroughly considered? We have published for 30 days, and NERSA has taken the decisions by the 5th of May. We also don't like that, but that is the reality because we cannot ignore the judgment. So I hear the proposals also from you, Chris, for the, I think now my response clarifies that issue, that we don't have any discretion for now. We'll have to comply with the 5th of May because there are only two things, is the MFMA, Section 43, as well as this judgment. But we need to engage. It's not a question of just doing what we want as of now. Before, if we don't like the judgment, and we believe that there's something that must be done with the judgment, we don't just ignore it by not doing what it says. It means a process, a legal process must then be instituted so that we can be able to bring these things to the courts and say, this is impractical. This is how the EDI sector works. And also this is how this process is managed in terms of MFMA and other pieces of legislation. And therefore this judgment is, if it makes things difficult, then we can indicate that this judgment makes things difficult. But we have not started that process. And Mr. Moratti has indicated it can be started by any other stakeholder that is affected, that feels that these timelines are simply not practical. But I also said that to the extent that we don't have time, can we just for 2026, 2027, and I said it might not be a permanent process, just for purposes of managing the times, at the same time complying with the orders of the court. Can we then just comply with that? Other than that, we can't ignore the laws and also the judgments that are delivered by the courts. I hope that that is clarified. When it comes to your question, Nombulelo, with regards to what if no application by Eskom? Eskom has never failed to submit an application. It is just that it is late. Usually Eskom will always submit an application in January. It puts us under pressure, but we still deal with it. And also, Eskom knows very well, if there is no ERSA application, we take what is translated from the revenue application. Remember, we've got the MYPD6 application. We have a revenue that is already approved for 2026, 2027. And we have also indicated in our decision then that with the revenue for 2026-27 of so much, then this translates to a tariff of, I think it's plus minus 5 point something %. So if there is nothing else, that decision stands. It means, therefore, they will not do any other thing. It will simply be that 5%. Because it translates from the approved revenue. And we had shown that with this revenue, what is the corresponding tariff tariff amount that is applicable for 2026-27. That will be a default and nothing else. So if Eskom then brings the ERSA, it will bring other things such as the RCAs and all of those other things. Then maybe they are in the ERSA. If it fails to do so, we take the default that we have already approved. That is the clarification insofar as do they get anything or don't they get anything? So they get what was already approved and nothing else. If they wanted to add with the RCAs, they would have to bring the ERSA in time so that we follow process. There's a question by Prof. Valley. Prof. Valley, you know very well how difficult these issues are. And at this point in time, you will also recall that NICOM is busy with the EDI roadmap in terms of reforming and diagnosing the challenges with the municipalities and so forth in the distribution sector, and also how to modernize the distribution sector and all of that. part of the findings there also require NERSA to do certain things. So we already know that. We also just in November made some comments there, and the regulator has approved such comments that they go to the NICOM. So yes, there are issues of affordability, as you know. There are issues where even the municipalities face certain challenges and they're not able to recover the full tariffs and things like that. But how those things are going to be dealt with, how the municipalities are supposed to be financially sustainable, how do you deal with the effect that the municipalities also face non-payments, in as much as ESCOM faces non-payments. So all those are all the things that we are discussing. It will be very difficult for the regulator to say, how can we resolve this issue? And obviously, it's not an issue that the regulator alone will be able to address. But I think that it will need a multi-party, if I were to, say that, but it will need the efforts of everyone to look into how to do this. And I think already there is some roadmap. There are certain proposals that are made in terms of that roadmap. I'm not sure whether that roadmap has already been shared with AMEU as well as SALGA as to what are the findings and also how these things are supposed to be addressed. But there's also the issue of affordability that needs to be dealt with. And it has been raised also last week, I think, or 2 weeks ago in Parliament, the issue of affordability, as all of these things that are going to be done, and modernizing the distribution infrastructure and the transformation that is happening. I think those are things that maybe at the right time, NICOM, also through the Department of Electricity and Energy, will probably come forward and address. But from our side, we just take cue from that process and what they would like NERSA to look into. Thank you so much. I think I've dealt with some of the questions. Mr. Morati, you can then take others. But just on the last point, NERSA will definitely share or issue a media statement with regards to the judgments and what are the implications of the judgments in terms of the timelines that NERSA must follow for 2026, 2027 for the municipal as well as private distributors tariff application process. That will be done by NERSA. Thank you very much. Mr. Morati, did I leave anything?
No, you have actually covered all the issues, save to say, for those that didn't see the note, we will post the judgment that, considering that it was issued yesterday, we'll post the judgment to our website. Alternatively, for the emails that we can be able to access, we would generously upload them and send them directly so that they are alive to the issues that we are talking about, including of our media statement that will be specific only on the timelines. Thanks.
All right. I think Prof. Valley has his hand up. Mr. Matebul.
Yeah, Prof is violating the process because I had wanted to close, but I will give him the minute.
No, Chair, I won't take a minute. I just thought I should put my hand up with no intent to violate the process, but if it's so, then I apologize. Why I put my hand up was, Madam Chair, you've been emphasizing the timelines, which is a valid emphasis. I was just thinking aloud because it would be ideal if you get all 178 or 200 municipalities submitting their tariff applications earlier than March, right? But in life, there's no free lunch. I mean, there's incentives. Now, I want to put something on the table, which you may shoot me down, and say you're talking nonsense or smoking grass. But let me put it on the table. In other words, is it possible, only for this time around, that because municipalities, because not all municipalities are well resourced. I think that's common knowledge. Some are actually badly resourced. Now, if they're incentivized to bring in resources, now here I'm talking about university students that are going on holiday and other people that would be on leave because we're in a silly season. If they can utilize those resources to fast track the tariff applications, and maybe you put a cap. I'm saying maybe 0.25% or 0.5%, and say if you can justify. So there's no guarantees. If you bring in extra resources, Mr. Municipality, to enhance your tariff application so that we're able to submit it before March, and you can set the timelines for that incentive, then maybe you can get the majority of all 200 or 178 municipalities submitting, because the other fear is that we could rush. I mean, this is reality. Right? They could rush to submit the tariff applications, and it may not be the best tariff applications. But if you have more resources, reasonable resources, then you may get reasonable tariff applications. But as I say, in life, there's no free lunch. So I'm suggesting if the regulator wants to consider that 0.25% or 0.5% maximum as part of the cost, which can be amortized on the tariffs, maybe that's the way. But I'm welcome if you shoot me down, Madam Chair. Thank you.
Thank you very much. I think you're making a very progressive suggestion on two things. One, the submission before the 20th. The 20th was not like a sort of a thumbs up, but we were very worried. We would have wanted to say the 15th, but then we thought maybe let's give the municipalities 5 days, right, after ESCOM's ERSA. So maybe give them 5 days to just work out how much they would need. Hence, we then ended up with the 20th of March. Ideally, we would have wanted it to be early, as you also indicate, because it is going to be very difficult for the regulator to do its work and still publish the applications and make decisions by the 5th of May. So that is something that we really wish we could do. But you also had some of the municipalities indicating some challenges. Some of them said they can manage, they've already started. And there are obviously challenges, and it's going to be a painful change and adjustment from municipalities. We recognize that, in as much as also from our side, it's not going to be an easy process to deal with. Hence, I was saying that now that we are confronted with this challenge, let's see how we navigate our way, just so that at least we comply with the court order, just for that. Then I'm not sure, because I cannot preempt maybe what is supposed to be the cap, because the reason is that municipalities have the cost of supply studies, and some of them, the increases that they had requested were below the outcomes of the cost of supply studies. So in many cases, if the cost of supply study said they are supposed to increase by 20%, I'm making an example, the municipalities have only requested an increase of, say, 14%. So there are instances like that. So I believe they still have some room to consider, and also taking into account the affordability and the comments from the stakeholders. But also that ERSA process is important, because the municipalities cannot simply absorb the costs, right? Because if ESCOM then gets what they want, the municipalities should also be in a position to be able to recover its cost, as you also pointed that out. But municipalities must be able to split the cost, because now we're getting to that era where we're getting to the market, and just like Eskom has done, to split the cost so that we know what are these costs for. They are well justified. Municipalities should begin to look into that for transparency purposes, so that we understand what are these costs for, other costs, even the fixed charges and so forth, so that after the approvals, we don't have these protests that we have seen in this year and the years earlier. So that's what I would then suggest, that they still have, I mean, the framework talks about escalations. So if the municipalities feel that they can follow what the framework is saying on escalations, and that also does not nullify the issue of the challenges with the cost of supply studies at the moment, but we work with what we have and then try to correct as we go, as we go forward, and just make sure that things are done properly. Thank you.
Ms. Masetti, you can wrap it up, and this will mark the end of today's engagement, and over to you, ma'am.
All right, thank you very much. I don't have much to say, but I just want to thank you all for coming out in numbers, and it was very encouraging to see everyone responding positively, and it was like this is something that you were really looking forward to, that we can, you can have this kind of conversation with the regulator, and I'm hoping that these conversations don't end today. There is still a lot that we need to engage on as between NERSA and the distributors, and we should keep this up. Obviously, as we indicated here, and that should be the action part of the action plan, is that there's going to be a follow-up on the cost of supply studies. I think that's one of the key things, so that we deal with the challenges of how they were done, certain areas that may not have been done properly, and how we deal with that. So that is the first thing. That is the sort of the action plan. So we will have that engagement. The second thing that we are going to do is to issue a media statement that will deal with firstly, the court judgment that was delivered yesterday in terms of the timelines of that court judgment, and deal with the one or two challenges, but also in that media statement we'll also indicate the deadline for, which is the deadline, but one can submit even earlier, the deadline for the submission of the tariff applications for 2026, 2027. And that deadline is the 20th of March 2026, because NERSA is required by the court to finalize all the applications and take the decisions by the 5th of May. So that is the second thing that we are going to do. And then the third action is the high-level engagement that we need to have, and we need to have that also very quickly. The one between NERSA, COGTA, National Treasury, DEE, SALGA, and the others for alignment purposes, and that will also assist in coming up with a plan going forward in terms of the process that must be followed, not only in 2026, but also in the other years in terms of the tariff application processes, and also the compliance with Section 43 of the MFMA, and also recognizing other provisions of other pieces of legislation. That is the third action in terms of this. Yes, the other thing that I just want to emphasize is that there is no grace period that was granted by the court in terms of its judgment, meaning that order, for as long as it has not been set aside, it is the order of the court that must be complied with. So we must try to comply with it, at least so that we can manage the 2026-2027 process very well. We also just want to emphasize that we are all concerned about the discrepancy and misalignment between these the court order in terms of the timelines that it prescribes, as well as the timelines that are in the in section 43 of the MFMA. So unfortunately, that's why we find ourselves, let's just work together. And then I want to also just emphasize the submission of the 6 monthly progress reports for the municipalities that were requested to show some improvements in the areas where they have not been performing very well, also from the financial performance and the other things that the municipalities were required to do. And the other point that I want to emphasize is in relation to the deforms, that the date of 31st October is not the final date. And also there we only have a response of like 64%. So we want that to improve. Please, if you can assist so that it can also assist your applications as well. So if you can kindly make sure that you update, revise the data that is there, data that is the most recent, that will assist us, and that will not be inconsistent with your cost of supply studies, which inform the tariffs. Please, if you can do that, and so that we can get access to the most recent information. I'm hoping that all of these things then are going to assist everyone in terms of preparing the applications that we expect. And so far as ERSA is concerned, Eskom knows very well what the implications are, and we expect Eskom, because already they touched on it, we expect Eskom to apply for it in January. We will also from our side just to make sure that they apply early in January, not end of January, otherwise it's going to be a problem. So we will make sure that Eskom submits at least mid-January, submitted the ERSA application. Then we have the 30 days of comments. Before the 15th, ERSA would have taken a decision, like we have always done when it comes to ERSA. We have never been late taking the decision after the 15th of March. With that, I would like to thank you all, and I appreciate your inputs. I appreciate your suggestions, and I think they can build us and they will help us in navigating the changes that we need to make. And I think there's still a lot of other things that we are going to do together. As I mentioned, the findings as well as the proposals that are in the ETI roadmap, which you're probably going to see them, in the near future. So I look forward to further engagements. With that, I would like to thank you all. The workshop is now closed. Thank you very much.